own monkey.
Get your own monkey. This is where we laugh. Welcome to the Say I Won't podcast, season 4, episode 3. No intro this time. We have a special guest with us today. And then I don't know how it's set up on your guys' layout, but we got the loser down at the bottom. His name is Isaac Chase. I don't know who's at the bottom for you guys. On my side, it's that guy right there. But we do have a power attorney. Is that what we should call you, power attorney?
Yeah, super lawyer. That's right. Yeah,
Brian DeBouche. I said that right.
DeBush. Close enough.
DeBouche. Close
Yep.
enough. All right.
In his broken English, he got it.
In his broken,
Right.
yeah. I'll blame it on the ESL. Anyways, I'll let you guys kind of introduce yourself and say a little bit about what you got to say about yourself and what you do and that type of stuff, and then we'll get into this conversation that we want to have about pews.
Okay, I'll let Isaac go first.
I'm Isaac Chase, and I got nothing special to say compared to what Brian's got to say. So, so Brian, go ahead and tell us kind of what your professional background is. I mean, you don't have to go into where you went to high school, but a brief review of your recent resume, I guess, would be nice.
So I'm a lawyer here in Colorado. I've been a lawyer for 23 and a half, almost 24 years now. As of October, it'll be 24 years. I've practiced criminal, civil rights, domestic relations, commercial litigation. I worked for AT&T for a while, Comcast later. I've done a lot of work around, obviously, gun rights, defense against gun charges, defense against crazy charges that involve guns. I've got current clients, I've got current appeals, all involving those issues. And obviously, your organization is one of the clientele that my firm currently has. So I've done a wide range of cases in a wide range of courts. And I today what I wanted to talk about was the recent grant of cert on the Corlett case in the Supreme Court, and that's the U.S. Supreme Court, not state. And I'll explain why those two jurisdictions are quite different, why you don't have the rights that you think you have. I mean, it's the same thing that Edgar and Isaac have heard me say it a dozen times probably, but I'll say it again. You may think sort of on the street what the law says you can and can't do, but for the most part, people are mistaken about what sort of that common knowledge says, and the actual law and the actual practicality of what you can and can't do are completely different.
Yeah. And before we kind of get into what we came here for, and that's the Supreme Court, and maybe a few other things, I do want to note, and I kind of want to give you a little bit of praise on here for helping our friend over at 1770 Armory, Sean. He had kind of a bullshit case. We know it. But he was sweating balls. He was a little worried. He didn't think that was going to work out the way it worked out. And he trusted the process. He trusted what you were going to do. And you got his case dismissed. Can you talk about that in any way, shape, or form?
Not without his permission, unfortunately. Perfect. I can't even acknowledge that he's a client. So unfortunately, without
so we don't even know if he's a client or. We should bring him on right now just to say yes. I give you permission.
If he comes on right now and talks about it, yeah, that would give me full permission. Yep.
You passed the first test, so we know you're a real lawyer.
Yeah. Rules are rules, unfortunately. So I've got to follow all of them.
Now we can't even talk about it in the abstract since we already brought it up. So now we have to avoid that topic completely. But
what we can do. Go ahead.
I was just going to say, I did talk to him about it, and I'm not going to talk about the case or anything like that, but he did talk about, he told me that you did a fantastic job and that he was very impressed with what you did in his case. And it's an interesting case, and we talked to him while it was going on. We talked to him on the podcast while it was going on. But I would like to talk to him again because it's just about resolved from what it sounds like. It's not completely resolved, but it's pretty close. And I would definitely like to get him to tell the rest of his story, because it's a pretty interesting case, and there's a lot of relevance to just regular concealed carry. And I think a lot of people, this is what I tell people in my classes. I'll tell them what the law says, and then I tell them, but anything can happen. Anything can happen, and it doesn't matter what the law says. It matters what happens at the scene, and don't be surprised by anything. Don't let yourself believe that you are immune from any kind of trouble just because you know and are following the law.
That's exactly right. That's exactly right.
Yeah.
And so there's a whole conversation we could have on a different podcast about the 5 current bills in the state of Colorado that aim to limit either gun use or possession or ownership. We could talk about red flag laws. We could talk about all of the current movements in this and other states against gun ownership. We could talk about the sorts of reactions that people have to, for example, over the weekend there was a shooting in the Springs, and the reaction to that is probably going to be negative for those who appreciate gun ownership. But that is the cycle that we're back into in this and other states. And so what I want to really portray is the impact that this Corlett case may have on all of those conversations, even in this state, even for existing laws, even for the limits that already exist. That case may be a watershed case in a way that we've not seen for 13 years from the Supreme Court.
So let's set this up a little bit.
Yeah.
The Supreme Court has finally granted cert to a gun case after having not done so since the decision right after the Heller decision. What was the it wasn't DC. What was the? I always forget. I remember
McDonald
Heller
v. City of Chicago. Yeah,
McDonald,
is what you're thinking of.
Which is actually interesting, relevant, because we know a guy who actually concealed carry in Chicago and did have to shoot somebody. And he ended up walking away from that relatively unscathed.
Wow.
Legally speaking, in part because of his legal representation, but also in part because of the officer's response on scene, from what it sounds like. But that probably wouldn't have been possible had it not been for the McDonald decision. So let's talk about this decision. It's the first decision in what would you say, 12, 13 years?
It's been about 13 years since they've really taken up an important gun rights case, and one like this. It's been 13 years. So the prior case was Heller, then we had McDonald, and now we've got Corlett. And the sort of the chain and the development of the Supreme Court doctrine is going to either be a watershed case or a huge obstacle going forward. One of the two.
Okay, so to reiterate, in one sentence, what was the landmark decision of the Heller case as opposed to the McDonald case?
So Heller was a case out of Washington, D.C. It was a case involving a total prohibition of handgun possession and use, even inside of your own home. And that was the important part for the Supreme Court in Heller, was A, it involved your home, and B, it involved a handgun. And so Heller involved that total ban. That is probably the one sentence I could use to summarize that case.
Okay. And then McDonald afterwards?
Let me get down to my notes because I got to be careful about how I describe that one. All right.
See, and this is what did you just tell me? Shush. I'm just kidding.
Oh no,
it was perfect timing.
Hush.
It was hush, little peasant. That was great timing. But this is what I appreciate about Brian. Is there's no bullshit. There's no like, this is what I think. It's always like, let me see the notes. Let me see what the fuck is really going on here. But go ahead. I distracted you.
The twist of a phrase can change everything. So really what McDonald was about, and you have to think of the U.S. Constitution with the Second Amendment in it, as opposed to all of the states with their individual either constitutions or legislation governing handgun and firearm ownership and use. There was nothing really up until the McDonald decision that said the Second Amendment applied to the states. Not really.
Well, isn't that true of all of the first 10 amendments?
8. So the first 8 amendments, exactly,
Okay.
until they began to talk about incorporation and the Equal Protection Clause as incorporating all of those rights for all of the states, there wasn't really anything. You're right. Once they began to talk about incorporation, they were selective about it. So they talked about the First Amendment. They talked about, portions of the other amendments, the Fourth, the standard, due process sorts of protections for trials. But what they didn't talk about, you had Gideon v. Wainwright, you had all of the cases that established protections for criminal defendants, for example, but they didn't talk about the second. And the reason they didn't is because we had this patchwork of laws across the country that prohibited concealed carry in some places, prohibited open carry in other places, allowed free reign in some of the states, especially those with lower populations and more agricultural backgrounds, free reign to do whatever you wanted with a firearm. And so you had this patchwork of regulation across the country. But until McDonald, even the Supreme Court had not said, we find that the Second Amendment applies to each of the states, and that there's something fundamental about the Second Amendment as it applies to all of United States citizens. And so that really is the incorporation case that said there is that right, and it does apply to everyone, and it's sort of a universal thing in the United States for everyone to have that right. Now they didn't explain it much more than that, but that's what McDonald's sort of known for.
So D.C. Heller affirmed the right that helped define the Second Amendment as a right to keep, for lack of a better word, keep arms. But because it only applied in D.C., the McDonald decision was required to come along and augment that by saying it applied everywhere across the country. The Second Amendment applied across the country.
That's not a bad way to describe it, but here's the more specific way I describe it. So the Heller decision talked about individual gun ownership, particularly handgun ownership, self-defense situations, and possession in your home. So it just talked about that broad ban and talked about the ban on home use and ownership of weapon for self-defense and particularly handguns. McDonald comes along and says, we incorporate that sort of right for everyone, that you can defend yourself in your own home, ultimately, is how limited that could be taken to mean. And then what we have in Corlett is, I think, what you were looking for, which was, if the Second Amendment applies nationally and it's incorporated against all of the states and it's a fundamental right, then it must apply outside of the home as well. In other words, is it just limited to your house? And so let's talk about Corlett for just a second. So in Corlett, it is, sounds like a New York Rifle Association and some of its members. They were really active after Heller in bringing litigation federally to try and expand or overcome some of the restrictions that exist in New York. And New York, so you understand, it has had restrictions, Sullivan laws in place against firearms ownership, especially concealed weapon carry, since the turn of the last century. So 1900, 1911 in particular, they had passed a lot of laws restricting gun possession and ownership in public, at home. They had established licensing requirements. The licensing requirements were very strict. They had licensing officers that you had to go to get a license to do anything with a firearm. And what they did was they just restricted use of a handgun to just specific situations. So sporting, target shooting, hunting, those sorts of things. If you could establish that need, they would give you a license that allowed you to meet that need only. And so that was in place for a long, long time. The plaintiffs in Corlett then sued because what they did is they went to the licensing officers and they established really nothing. They said, we just want to have licenses issued because we're citizens of the United States and we believe we should have the right to carry firearms outside of our home for any purpose, for any reason. And the licensing officers, of course, took out the big no stamp and stamped it no and sent him packing. But I think it was a deliberate strategy by the New York Rifle Association to set these cases up to challenge those restrictive laws with the latest line of cases from Heller, and sort of given the timing and the makeup of the Supreme Court, they probably picked both the right time and the right place and the right law to challenge it, because Out of the 10 cases that the Supreme Court had last year to consider that were arguably gun rights cases, and based on prior conferences where the Supreme Court really steadily denied over and over again prior cert petitions on exactly these issues. And it looks like there was at least one prior case where the same rifle association had a challenge to transport of firearms in New York State because there was a ban on transporting firearms even in a vehicle in New York State unless you had a license that would allow you to transport the firearm. They challenged that law, and New York repealed the law in the meantime. So the Supreme Court never even heard that case. But out of all those cases and all the passage of that time, what came out of finally consideration of all those petitions was this one Corlett.
So do you think that this Corlett decision, I'm sorry, not the decision, but the case itself, is the natural progression of the definition of the Second Amendment? Is that possibly why this was granted cert by the court? Because this, like if you were to put the ideas in sequence, first you establish under Heller, then McDonald, and then this comes next. Is that your understanding or your best guess?
That's what I would say. Is this is the evolution of both the incorporation of all of the rights against the various states and their interpretation of what they believe their citizens have under their own constitutions, and then it's the natural progression of the Second Amendment as being treated on par with the other 7 amendments that are included under that incorporation clause. So if you think of the right against double jeopardy, the right against the right to effective assistance of counsel, probable cause determinations, search warrants, you think of all of those things as applicable to each of the states federally. The Second Amendment just wasn't treated the same way. And until we got this line of cases after Heller, we just weren't going there. It was really treated completely differently prior to Heller, and that was the first time it was given the same treatment as the other rights.
So can I ask a procedural question?
Yeah.
I learned this at one point in my life, but I forgot. How do the courts decide to grant cert to a case? Is it a majority decision or?
Boy, that is a tricky question. So in this state, it is 3 justices voting on a petition for cert to grant cert. And a cert grant, if you understand, when you get through all your other appeals and you get to that last step, all you're asking is for this discretionary grant of your ability to argue your case. And then, the Supreme Court handles, tons of petitions per year that they reject. There is a small percentage, and I don't know offhand, but a small percentage that make it past those conferences and actually become a vote. In terms of our Supreme Court, I don't remember how many judges it is that has to vote for cert. But they have to have some minimum number of justices that vote for cert. After you vote for cert, that allows you to actually brief and then eventually argue in a public hearing your actual issue. And when they grant you a certification like that, it doesn't have to be on the question you wanted. It doesn't even have to be on the issue you raised. And in Corlett, that's exactly what happened. Is instead of granting cert on what they wanted, they've got cert for what they got.
Okay, so the court reviews the case and says, yeah, there's an issue here, but it's an issue that we think is important more than what you guys think is important, and that's the issue we're going to decide on. We're not going to we're not going to go beyond. I know that the Supreme Court always tries to keep their decisions as narrow as possible on the issues that they do pick up, and the number of issues they pick up is almost 0 compared to the number of issues that come before their review. Mr. I don't have my glasses.
Mr.
Mr.
Knives.
Knives asks, could this help California?
If it goes the way that court watchers expect, given the voting patterns on the court so far and the way they've treated sort of this decision, as being important to them now, the expectation is it's going to be, as I said, just a watershed case across the country.
So you've mentioned what the initial issues of the case are,
Right.
and you've mentioned what I don't know if you have mentioned, what did the Supreme Court say was the issue that they were going to be deciding on?
So when these two guys, so it's Robert Nash and Brandon Koch, and they're members of the New York State Rifle and Pistol Association. What they did was they had set this up so their licenses were denied, and what they wanted to petition for was certiorari on the following question: whether the Second Amendment allows the government to prohibit ordinary law-abiding citizens from carrying handguns outside the home for self-defense. Now that seems like a pretty broad question, but that also seems like the most important question, right? And it seems to be strongly implied from Heller that the answer is you do have that right, that you would have that fundamental right, and it would be applicable against the states. That seems to be the logical answer to that question. But what they granted certiorari in the order on was this: whether the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. So they took that broad question, which we would all agree is probably the one we want answered, and then they shrunk it down to a different question.
So the broad question would be, can we have constitutional carry across the country?
Right.
And the narrow question
Exactly.
is,
So that's
can a state deny you the right to carry, deny you a permit for the ability to carry?
The question they wanted to narrow it down to was, can you deny these concealed carry permits in the state of New York? And if you do so, does it violate the Second Amendment?
Okay.
So they reframe it in a narrower way. I think it's still the same question ultimately, but they reframe it in a way that gives them potentially a couple of outs on this, because they can send it back potentially to be reconsidered and the licenses regranted if they set up a new standard, or they set up a new test, or they approve of New York's sort of licensing restrictions and the standards they use to deny these, or they make the petitioners go back and reapply and establish grounds for why they want to concealed carry. But the question that we all want answered is the first one, which is, can we walk outside with a gun? And if we do so, what are the risks, and what do we have to, have, for example, in this state, we have to have a concealed carry permit in our possession at the time. We have to have that, permit approved. Most, counties are considered shall issue counties. And so, it seems like a fairly simple process. In New York, it's completely different, and almost no one gets those licenses. Not broadly speaking. They can establish a need if they have a specific need, but most people are denied, it looks like. And so the difference here comes down to what 16 states do as opposed to the rest, and that's what it ultimately comes down to.
So 420. Or no, 420. 42 Chilled said he looked it up. He said it's 4 justices for the approval or for cert. Okay, so that's really narrow. So you're saying this is potentially a landmark case, but at the same time, we're talking about a really narrow issue that could be easily disregarded. Not maybe disregarded. Can't be disregarded, but can be easily gotten around by maybe the 9th District, or a justice or a panel of justices that are not favorable to the Second Amendment.
Well, I would say yes and no. Depending on how they write that final opinion on this case, I think it's going to have an impact one way or another, and it's going to be tremendous. They narrowed the question down to whether the state's denial of these applications was a violation of the Second Amendment. But I think, as I said, it's still that first question. And the answer to the first question or the second is going to be either there is a fundamental right to carry outside of your home or there is not. If it's some other version of a right that is not so fundamental that it can be restricted in some sense, then what are those restrictions or standards? And how does a higher court analyze the restriction? Because that's going to be a huge fighting issue. How does a higher court, any higher court, analyze a restriction when they next see, Chicago or Florida or some other state come up with, another scheme for how you apply for licensing and deny, potentially 98% of the applicants? What do you do with that regulatory scheme, and what is the plan to analyze that in the future?
So this is kind of an unrelated question, but it is related. And then after that, I want to ask you Keith's question. Judges' greatest fear, professionally and probably personally too, is to have one of their decisions overturned. Does that seem true? I mean, broadly speaking, like that's
Professionally speaking, for most judges,
Mm-hmm.
The worst result, and you understand the difference between published and unpublished cases.
No.
So Colorado Court of Appeals gets most of the appeals. They do most of the heavy lifting. The Supreme Court here issues weighty and much longer and well analyzed decisions, and the ultimate say in the state. But the Court of Appeals does the heavy lifting, and they have far more judges on the Court of Appeals than we do here. We've got 7 on the Supreme Court. I don't remember how many Court of Appeals judges we even have anymore. I thought we had 15. But in any event, you have 3 judge panels, and when they issue a decision, most of those decisions are unpublished. So judges do not like to be reversed, but they would much rather be reversed in private than in public, if you understand the difference.
Right. Okay.
An unpublished opinion doesn't impact you the same way that a big published weighty opinion has on your reputation in the community and your professional standing. If you're reversed repeatedly, you've really got issues then.
Right.
And so that's the difference here. In terms of federal courts, most of those decisions are easily available. In terms of stuff in state, it's a little harder to find the unpublished opinions of the Court of Appeals.
So what I'm trying to get at is basically, if the Supreme Court rules on this case in a way that makes it somewhat dangerous for a published decision to kind of tread into unknown waters, they may be less likely to rule against maybe the spirit of the decision, to prove a point or to be activist or whatever.
Right.
So there's a possible benefit there that it creates a situation where local courts and district courts do not want to wade into that territory for
Right.
fear of being reversed on a,
Mhm.
or even, I mean, if you think about it, even just bringing this topic up again for review at the federal level. So, okay. So Keith has a question regarding Colorado SB 21-256 concerning permitting regulation of firearms by local government bodies. Could it be considered unconstitutional when factoring in the DC versus Heller decision? So SB 21-256, is that one of the new bills?
Yeah, that's one of the bills that was just introduced. They introduced 3 of them. One of them is to basically reverse what is currently CRS 1812 Part 2, the one that was passed in 2003 or came into effect in 2003. They're looking to essentially get rid of that, and more specifically 1812-214 subsection 1, where it says that local government does not have the authority to adopt or enforce an ordinance or resolution that would conflict with any provision as Part 2. So they want to hand it back over to local governments. So in essence, local governments could again start prohibiting altogether the possession of firearms.
Oh, this is the Denver Boulder split. This is that Denver Boulder issue that we've had for years and years now.
Well,
where
yeah, but
Denver.
now they came up with it on the Senate is the one that's
So
a
what
few
Keith is,
senators.
yeah, what
Yeah.
Keith is saying here is how does the DC Heller opinion or ruling possibly affect this particular bill?
Okay, so um, think of Heller for just a second, and I'm gonna start using metaphors here because it's easier to think of it this way, maybe. So Heller, McDonald, even Corlett, they have this ripple effect up and down the legal system, and the legal system moves, for the most part, at a pretty glacial pace. Some things move it a little faster than others, and so Corlett's going to be a wave. Heller was a wave, if you understand, why I describe it that way.
Mm-hmm.
In terms of Heller, I think the city and county attorneys have absorbed what that opinion is going to require of them, and there's been attention paid to some of the other cases that have followed through the federal districts after that opinion. So would that uh, passing of authority to local governing bodies be unconstitutional on its face? No. No, it wouldn't be. You could delegate it to your neighborhood watch program if you wanted to. That wouldn't be the problem. The problem comes under Heller when you regulate under the second, regulate in violation of the Second Amendment the possession of handguns inside of your home. You do it in a way that does not comply with what the Supreme Court's already said is a fundamental right. So if these local governing bodies don't understand the implications of that opinion and they try to legislate against it, they will come up against lawsuits really, really quickly and appeals really, really quickly because they're not going to be able to stray very far from. And I can tell you even existing laws have not changed in response to the Heller opinion, and that was 2008. So we've had plenty of time to react to that decision. Most of the lawyers now understand, if they're working in government, what that's going to require of them. So, delegating the authority downwards won't be the problem. The problem will be overreactive either city councils or county commissioners who want to get on board with absolute bans or total bans or prohibition of transport of weapons and firearms or concealed carry regulation, which we've talked about before. Those are going to cause issues, and I really think they are going to, if they get the authority to enact any local ordinances concerning those sorts of issues, they're going to tread very, very carefully and very, very slowly, and probably attempt to ride into uh, some of those same sort of prohibitions that have been a problem. But you end up challenging those one at a time.
So you said the judicial system moves very slowly, and you can see that with the Heller and the McDonald decision because we do still have remnants and elements of gun laws. I wouldn't even say remnants. I mean, we have major pieces of law across the country that would seem to
Yeah.
be in violation of Heller
Mhm.
and McDonald. And if the Corlett decision goes the way we want it to, we're still going to experience that. So people will ask, is this going to be a good decision for Colorado in the long run? I would seem to think yes, but don't expect any big changes, all at once or even over a short to medium long range of time. It takes time for lawsuits to become relevant, to be filed, to be argued, to be kicked up the chain of courts. The district decision, the ninth district decision about magazine bans, that was a pretty groundbreaking decision, and it has had zero effect from what I can tell on the ground.
Right. And so here's the way that plays out. If you read through some of the cases that talk about those restrictions, and New York was probably one of the earliest to adopt some of those laws. We've definitely got them here in Colorado as well, but there are restrictions where they attempt to justify it with police power. They say it's part of the government's police power to, and part of a compelling need by the state to prevent either, crime or public violence, and they justify restrictions on what they consider to be more dangerous weapons. And so that's how you get high cap magazine bans. That's how you get sawed off shotgun bans. That's how you get, gosh, we still have switchblade bans here in the state. We got a couple other weird ones. Oh, SAPs. You can't, a ban on SAPs and
Blackjacks.
nunchucks and blackjacks and all
Mhm.
these weird things. But that was the concern behind those. Those have been in place for 100 years, and so those sorts of concerns and those regulations are different than the sort of raw question that they had in Heller, which was handgun in my house,
Mhm.
and why can't I have one?
Yeah.
Uh,
And this is my own personal opinion, but I wish more people understood this. It is painfully slow to see how the court moves.
Mm.
But the alternative is very quick movement by the court that can fundamentally change society, very, very and be very disruptive. And while it's frustrating sometimes to see how slowly this stuff happens, when decisions don't go the way you want them to, you do not want that kind of thing to be swift.
Right.
So
That's the
yeah.
truth. That's the truth. Hey, Edgar, I don't think I can share my screen, so maybe I just got to talk about this next thing.
Hold
It says my
on.
device is not able to share.
Oh, it's a device issue. It's not a.
That's what it says. Yeah.
Huh. That's weird. Let me see. If
So
there's something
while you're
that I
looking
can
at
do.
that, I'm gonna respond to what Keith followed up here. It says it also create innocent criminals for crossing county lines without knowing all their laws. This is the problem that the statute originally tried to fix and it's explicitly stated in the law in Colorado that to avoid confusion between the localities, that the law should be the same across the state. I mean, it seems like the Supreme Court has upheld this in individual decisions. How does the legislature plan on passing a law that seems to violate prior Supreme Court decisions in Colorado?
Make that question a little more specific.
So, hasn't the Supreme Court in Colorado affirmed that these laws, that the law saying that the laws need to be uniform across the state, that individual cities and counties can't make their own laws? Haven't they affirmed that that's the intent of the law? How does the legislature seem to be ready to undo that law, even though it's been affirmed by the Supreme Court?
So that's really more of a political question, probably, and less a legal question, because they really are empowered to do either one, and there's nothing preventing them from doing either one. The one thing that would prevent, no. Yeah, see, it's not the delegation of authority. It's not how far you parse it down or how far you spread it around. It's how you exercise the authority in the end. And
Okay.
I like Keith Michael's question about, how do you know? If you drive from Boulder to Longmont to Fort Lupton to, to
Yeah.
Greeley, how do you know? And that really is a problem. And it's even for lawyers, it's difficult to figure out. I got to go to the book. I mean, that's what we
Yeah.
call it. You got to go look it up because they really do differ that far from jurisdiction to jurisdiction.
Well, judging by the amount of bullshit interpretations of the law that we hear from students, especially students who have talked to police officers about what the law says, we can barely keep the state laws straight.
Right.
You know,
That's exactly right.
so
Let me talk about just one state law, and this is why I said, Heller's still catching us all and still catching up to us all. So if you look at the disorderly conduct statute, I think I talk about this in our classes in the past. But I've got an issue with this now that I've appealed.
What's the number?
So it's 189106F. It's the very second to last section.
189
106.
Yep.
106.
It's disorderly conduct.
Okay, so I'm going to share it on my screen. Is that what you were going to share?
Yeah, please, if you could.
Yeah. I'll
just
share
get
it
down
on.
to F.
I'll share it on my screen. There we go. There we go.
So you take a look at F, and this is disorderly conduct. So it's a misdemeanor. F says you're not a police officer. You can either display a deadly weapon, display something fashioned in a manner that someone believed it was a deadly weapon. You can represent verbally that you're armed with a deadly weapon. You're in a public place and you display it in a manner calculated to alarm. Now that's exactly, I think, the sort of law that's going to be pulled into question by the Corlett case. If they rule that you can walk outside of your house with a firearm in the open, concealed, with a permit, without a permit, however they come down with that question, and you're not a police officer, and someone, you're at the grocery store and you bend over to pick up the toilet paper at the bottom, and your shirt pulls up and they see your firearm and someone screams, or someone goes and calls security, or someone calls a cop, anything like that happens where there's even just an accidental display of an article or a weapon in public, I mean, that law is written so broadly, it has got to be constitutionally suspect, right? That
Yeah.
does not really inform you and I of what it is we are allowed to do in public if we choose to exit the house with a weapon. It just doesn't.
Yeah.
It's poorly written. It's so broad that if you say you've got any kind of weapon on you, or if you have something that looks like a weapon on you, and someone's afraid or someone's alarmed and they call a cop, I mean, you and I all know what's going to happen next.
Yeah. Yeah.
So
You're
you
gonna
have
be my client.
you've been involved with cases in Colorado regarding this statute. Am I?
Mhm. Yeah.
So how, like,
If I'm
without
not mistaken, I've and of course you can't talk about it. We've already established that. But I will say that I've had people that have had to come to my class
Mhm.
that were court ordered because of a violation of this particular law or something like it.
That's right.
So they come and they say, this is court ordered. You have to fill this paperwork out, or I need to follow up with an attorney, or whatever the case may be, because of violation of this law or something similar
Mhm.
to this law.
That is one of the very broad laws they use. You don't have to pull it. Doesn't have to come out of its holster. Don't have to do anything with it at all.
Correct.
If you walk outside and there's any kind of problem at all, right? And someone sees that you have a firearm, you're going in.
Yeah,
And so
because again, it says displays a
all
deadly
you got to
weapon.
do is
It
you just
doesn't
show
say.
it.
Yeah, it doesn't
Doesn't say
say
brandish.
holding it. It doesn't say
No.
brandishing. It doesn't say. And I think that's what people are asking. Hillbilly and DJ Play Nice. They're asking, like, what's up with brandishing? And if I'm not mistaken, there's no actual explicit brandishing law in the state of Colorado.
It's called menacing.
It's menacing. Yeah, absolutely menacing. Or in this case, it would be disorderly conduct. But more often than not, I think we see more menacing charges than we do see.
Well, menacing is a favorite because that's another really broadly written statute. This one's a favorite because all it requires is the presence of something that looks like a firearm or someone thinks it's a firearm.
Correct.
But it doesn't require that you put your hand on it. Menacing, technically speaking, doesn't really require that you put your hand on it. Menacing is by any threat or physical action.
Where's that one? Do you know?
Oh, 18.3,
18.
206. This is another one of my favorites to talk about in class because it's under the assault section, go figure. And it's not an actual assault. It's by any threat or physical action. So that's any act, right? That's anything you do. You knowingly place or attempt to place another person in fear of imminent serious bodily injury. How do you do that? By use of a deadly weapon or an article that someone reasonably believes to be a deadly weapon. Or you verbally represent again that you're armed with a deadly weapon. So the most sort of benign version of this is by any act, they believe that you've threatened or attempted to scare somebody with a deadly weapon. Now, the problem is weapons can be scary for some people. If you haven't grown up with them or worked with them or used them, and if you don't like them, they're automatically scary. And so I get jurors on jury panels all the time, and I have to ask them, do you own a gun? Do you know how to work a gun? Have you ever shot a gun? Some of the people tell me no. they've never touched one, and they're terrified of them. The media representations don't help. That sort of the stories that you see lately sure don't help. But some jurors will tell me they're absolutely terrified of them.
Yeah.
So I've got to exercise challenges to those people remaining on juries where a firearm's the primary issue, because they're not able to be fair and unbiased and neutral
Correct.
about a firearms issue because they know nothing about them.
Correct.
You can't be neutral if you're completely lacking in any knowledge about the subject matter, right?
Correct.
It's like having an Amish jury for a motor vehicle accident.
Well,
Really,
and slightly off topic. I mean, isn't that the whole point of having a jury of your peers? It'd be
right,
people that would understand your subject matter. It would
right.
be people that were gun owners and understand what the gun laws are and how it operates and
Yeah.
all of that stuff. Like, it makes zero sense to have
Right.
a butcher talking about guns because, I mean, you're a butcher.
Yeah.
Like, yeah.
And a more fitting comparison is you don't get a bunch of dog bite victims on a case about a dog bite.
Yeah. Yeah.
Because they're
Yeah,
all
absolutely.
afraid of dogs.
Correct. Absolutely.
Usually. And so that's the sort of problem that you run into is, the scary gun metaphor runs an awful long ways with some people. And so these statutes are designed, really to appeal to them.
So let me ask another question of your experience. You're aware of cases in Colorado. I know of at least two where open carry was treated as brandishing.
Mhm.
One in Loveland, I believe, and one in Colorado Springs.
Mhm.
And did these decisions help to solidify the definition of, for lack of a better word, of brandishing? Even though we don't have the word brandishing, did this help solidify those definitions across the state, or not?
So not, and so there's the legal understanding of what those cases sort of mean, and then there's the on the street understanding of line officers coming across someone that they find with a firearm, or something that looks like a firearm, or something that was portrayed as a firearm, or an airsoft gun. I mean, so the problem is, by the time you get down to the level of police officers and DAs considering charging decisions, and sort of the you know uh, they all receive a level of education about these things. They all are aware of what the raw law sort of says, but are they aware of individual case law that narrow or talk about sort of how those decisions are to be made to charge those people? No. More importantly, they're not aware of, for example, the affirmative defenses. Like, let's talk about high cap magazines for a second. There is a grandfather clause on that high cap magazine law that most officers and city attorneys don't look at until you bring it up. You meaning me, but if you're standing in court and you tell them that magazine's been in my client's possession for at least the last 2 decades. He's had the firearm, the high cap magazines, the ammunition. He's gone shooting. He got out of the military. He's got plenty of experience with that very same firearm, and it's he's always had those magazines. Uh, that to me establishes everything you need to avoid even charging the guy. But instead, you've got seizure of your weapon. You got a bonding decision. You go to jail. You got a ticket. You got court dates. You got all of this process you have to go through to get through what should have been a screening decision up front. Because most officers don't even ask.
Well, that can't possibly be the case, because I've been told many times that ignorance of the law is no excuse.
Man, yeah. So
I'm sorry. That only applies to the
that's the other way.
citizen.
Yeah. It's a sword, not a shield. Yeah. Yeah. I think, unfortunately, some of these lower level misdemeanors go through, county courts across the state over and over again, and DAs and police officers, they move around, they move on, they choose other careers. If they're not there for a substantial period of time, they don't have time to learn all the variations on the themes that come with the big, post handbook they get at the beginning of their training. It's, it lays out the laws. That's it. And so their charging decisions, although, they've got supervisors and they get, that stuff gets signed off on, or it gets presented to a DA. For the most part, you know, the, the experience and sort of institutional knowledge that you need to carry with you into those decisions doesn't last long in some of
Yeah,
those
well, for a
jobs.
beat cop, you're talking about a very narrow set of rules and laws, or
Right.
laws that they're going to regularly interact with.
Right.
And they'll know those pretty well because, if you make a bunch of arrests on something and you keep making
Mhm.
the same mistake over and over again, you're going to get called on it.
Mhm.
But I mean, as instructors, we have a knowledge base about a very narrow part of the law, and I have a hard time keeping it straight, and I teach it on a regular basis.
Right.
So it's not surprising to me that local police officers would have a problem remembering or knowing all of these nuances, especially as they change over time. But to me, there is no excuse why a district attorney, or a DA assistant, and its assistant attorney could violate, or not violate, but charge under one of these laws incorrectly. When it's your job to apply the law correctly, there should be no excuse for that. But
Yeah,
I mean, I know that we're living in a flawed
and
world.
here's the thing, like, and on that note, I had a DA in my class, and I kind of made a slight. You know me. If you've been in my class, you know me.
Yes.
I'm gonna talk shit about you either
Right.
way. So they made a comment. Oh, I'm a DA at this particular county. I was like, you're the enemy. Because that's how I've always seen the DA, is you are the enemy. And her comment to me was, no, like, I actually, like it or not, my job is to make sure you don't go to jail. Like, I am actually trying to prove in a weird way that you are innocent. And that kind of fucked with me a little bit, because I was like, no, like, your job is to make sure I go to jail. And it makes it hard to believe. Like, if her comment is correct, then as soon as you look at a case, and you see, no, like, I can't even pick this up, like, there's nothing here, like, it would make sense to me, like, I could take that more seriously, what she said,
Mhm.
because I wanted to believe her, like, everything in my being wants to believe her.
Right.
But then there's proof everywhere where it's just like, no, that's not it. Like we look at a lot of cases where they're making shit up or ignoring all of the evidence and continuing with the case.
Yeah. So, just like beat cops, they come in all different stripes and sizes. And so, there's two things I want to explain, so you understand sort of how the system works. The first is you get DAs who really take, uh, the ethical obligations they have as prosecutors very seriously. And one of them is to do substantial justice and not to prosecute cases where there really are no good grounds to believe there's a chance of conviction. Some of them really take that seriously, really do. I've had them dismiss quite serious cases, um, when presented with, what I believe to be contradicting evidence. They really took it seriously,
Yeah.
analyzed it, and decided not to prosecute. But those are becoming, rarer and more the exception than the rule. Here's what happens practically, so you understand. If you look, strictly speaking, at the criminal rules of procedure, Rule 4, 5, and 7, and you look at how a misdemeanor case starts out, nobody even looks at it, right? An officer fills out a complaint, gives you a ticket, you go to court, there doesn't even have to be a probable cause screening. There is nothing. Now, sometimes you'll get a magistrate or judge who will sign off on, potentially a warrant, and that's the first review that case will see. But most of them that march in on a summons, no screening at all. There's not a DA or city attorney that even sees it until it shows up in their desk in a file with a case number.
Yeah.
And then train's already left the station, right? You're already, in the system, and you've already had to, potentially, go to a bunch of court dates, cooperate with pretrial, lost your gun, lost your, car or something else, stuff's been seized. You've got, public appearances to make. It's embarrassing. I mean, that's how that sort of county court, Walmart version of law sort of works is you
Oh, I
just get
like that Walmart version of law. That's a good
yeah,
one.
because other than the greeter at the front door, there ain't nothing. You walk in, you walk out.
But
right?
can I walk in and refuse to wear a mask though?
No, not anymore. Not anymore. No, that's literally how that stuff sort of works at the county court level. Now, felony level, there's automatically, a DA intake unit. They have more experienced attorneys in there. They definitely screen through them, uh, some more carefully than others, and then they're approved for filing with specific charges. And that sort of system, can be challenged on a probable cause level for more serious charges, and so there's some scrutiny there. But at the county court level, where most of the cases live, now you got a Walmart greeter basically at the door.
And then the city level is even worse.
Even worse, right? Because there's almost nothing. They got hundreds of cases, from dog bites to prostitution to everything else under the sun, and they don't really have the time to look at every single one until it's
Yeah,
set for trial.
I fought cases on the city and county level, and I was my own attorney, so you know what they say about that shit. The fucking client was a fucking idiot. On a county level, I was able to win on a technicality. It was a default thing. Cop
Good.
just didn't show up. But I fought one in the city, and this was the first time I had done it at a city level. I was surprised about it. Just it stacked up against you. Like there's basically, as soon as you plead not guilty, it's just like you have no options whatsoever. Like there's no real trial. There's no there's nothing. There's absolutely nothing you thought you were gonna have at your disposal available to you. It's just basically no. It's like there's a 99% certainty you're gonna lose this thing because.
And here's what happens on every single one of those cases. You come in on your first day on your ticket.
Yeah.
And they give you an advisement. They tell you got to pay a $25 jury fee. They rattle it off to you in the midst of a lot of other stuff, and you fail to pay the fee. Happens 98% of the time.
Yeah.
People just don't know. They don't realize how important that is because you don't get the jury back. And then it's a trial to the court, and it's a trial to a judge who's seen 100 guys like you come in that week.
Correct.
And you're not special. You're not
At
different. You're going to struggle to represent yourself anyway. But most people have to at that level because they don't want to have to pay for.
Yeah, because it's a small little ticket. Like it doesn't make sense to pay what a good attorney is worth to fight a little speeding ticket. Like it just sometimes it does though.
Right.
Exactly. Next time Brian's gonna be there, he's gonna be like, "Dude, it's a fucking $50 ticket. Why don't you just fucking pay the thing?"
I went to county court to argue. I had 2 tickets for the same type of offense that happened 2 weeks apart, and I successfully argued with the magistrate to remove one of the tickets, and I was super excited about it. And then I got charged court costs that cost the same amount as the ticket did.
But you won.
But I won.
But you won, exactly. Yeah. Pat yourself on the back over it as you empty your wallet out. Yeah, it's something.
Yeah. So let's talk about. Yeah, let's get back to the Corlett case. I know you want to talk about some relevant stuff in Colorado related to what's going on with that case.
So here's the way this sort of sets up, so you understand sort of number-wise what's going on in that case. And all of the materials on Corlett are available online. If you go to SCOTUS blog, it's SCOTUS blog. You go to that website, and they do a pretty good rundown of everything, including, I think, listing out all the different amicus briefs and amicus filings for cert that went along with that particular petition. But
for the special ed students out there, amicus briefs are briefs filed by people who have an interest in the decision of the case, and try to supplement the argument by saying, "Hey, this is important because of this."
Yeah, and in that case, they've got a series of either rifle or firearms associations or law enforcement associations all filing, friend of the court briefs to go along with the request that they grant cert, because everyone wants to see some kind of decision come out. Here's the way the split sort of works out, and it's 16 states have permitless carry, so you can just, open firearms carry is a given in those states. You've got 8 states that still have may issue CCW permits: California, Delaware, Hawaii, Maryland, Massachusetts, New Jersey, New York, obviously, and Rhode Island. On average, it looks like from the sort of numerical studies they've done of those states, less than 1% of the applicants ever get a permit across those states. Now, here's the flip side of that from some of the amicus briefs. The studies they had of defensive gun use outside the home estimate somewhere in the neighborhood of at least 1 million defensive gun uses annually.
That's interesting. I want to take a very small detour here, because every gun owner will tell you it's 2.5 million, and every anti-gun owner will tell you, who knows anything about it, will tell you that was based on a very flawed study. And here we have a new number. We have 1 million. So can you just quickly talk about where that number came from?
So the 1.2 million came out of a CDC study. The CDC study estimated anywhere from 256,000 per year to 1.2 million annually. Okay. That was the lowest number, though, because the 2 other studies they've looked at said it's somewhere between 2.2 and 2.5 million annually. And these are all self-reports, because they don't always end up with police blotters and reports. So these are all studies done through self-reporting and polling. But what they found was at least 80% of the defensive gun uses that they were tracking were just displays of a firearm.
Right.
It was a confrontation where a firearm was displayed, and that de-escalated the situation and prevented whatever the confrontation was.
Right. And it would have to be, because there aren't 1 million people getting shot every year.
Right. But
or shot at.
There are apparently that number of people, or that number of incidents, regardless of how many people it is, where a menacing with a handgun, or a disorderly conduct with a handgun, led to de-escalation of that confrontation.
Okay. All right. And so I think we could safely then say somewhere between 250,000 and 2.5 million is our number.
Right. And so the number I think that we're sort of settling on is that it is at least 1 million per year.
Okay.
And looking at that kind of number, that's 1 million incidents. It may not be 1 million people, right? Someone may have to do that twice in a year, I guess. But it's 1 million incidents a year where there was not a shooting, there was not a violent result, there was not a robbery, there was not a burglary, there was not a carjacking because of the display of a handgun. That statistically seems to be a huge, huge result. No, that number is all defensive gun uses. It's not limited to CCW users. It's not limited to anything but U.S. Citizens and residents. And so
now, is that actually shooting?
That is not.
No.
That is
so any use of a firearm. Yeah.
Even just displaying it or brandishing it. Exactly. And so that's an impact on at least 1 million people a year. And so the Supreme Court, I think, has that in mind when they're looking at whether or not to rule on an issue like this and expand or contract or reanalyze sort of what they believe that right to entail. But they have to think of 1 million people a year who next time, if they decide to limit that right, may not be able to de-escalate the confrontation, may not be able to save their car or their kid or their home.
And just for context, we shut down the entire country to save the lives of supposedly because of the death of 500,000 people. That impact to 500,000. So, right. It's no joke to say that 1 million people are affected. Apparently, under the current standards of our public policy, 1 million people is no joke.
Mm-hmm.
Correct. Yeah, in the interest of keeping the same energy on all levels, our number is twice as high.
Mm-hmm.
So let's talk about what we're not going to get rid of. This case comes down and it says handguns are allowed outside of your home for self-defense purposes, and it's in its broadest sense that's what we're sort of hoping this case is going to set out in some fashion. You're still not going to be able to have a short shotgun. not going to be able to go outside with your, Browning automatic rifle. Probably still not going to be able to possess stiletto knives or any of those sort of, identified dangerous weapons. But, for a million of us, that's all going to be fine, probably. A million of us a year, that's going to be just fine, and that would be sound public policy, and it would make for a good decision. We're still not probably going to be allowing those convicted of felonies out to possess firearms outside of their homes. And in Colorado, it's important to sort of distinguish that. A felon in possession of a firearm outside of their home, in their car, at the range, out hunting, or anywhere else is going to have a problem, because you're a convicted felon, and federally and now in state law, you've got restrictions that are going
With
to
some
apply.
exceptions, though, right?
With some exceptions. However, the case law in this state clearly seems to indicate that you're a felon in possession of a firearm inside of your home for self-defense purposes, that you are authorized, and that's an affirmative defense to any menacing charge or felon in possession of a weapon charge that would ever be brought against you. So we're
Where's
not
that
getting rid
found?
of that. Oh, there are 2 cases, and
Oh, it's okay.
it's 2 cases that came out. Out of those cases, you get that self-defense doctrine for felons in possession of firearms, but it's applicable to your residence, your house, your home. That's it. So we're getting rid of those sorts of regulations or prescriptions. We're not. This is going to be probably limited to handgun possession outside of the home for self-defense purposes, and whether you have to justify that to a state licensing officer or not. And if you do, what do you have to show them beyond just ordinary law-abiding citizen sort of information? What else do you have to demonstrate for them? And I'll tell you, like I've had my concealed weapons permit. I've had to renew it once, so I've had it for the last 15 or 16 years. I've had it consistently, and if I don't get a death threat a year, I don't think I'm doing my job. So I get roughly a death threat a year, and the sheriffs are really good about, if you need to get your concealed weapons permit issued expedited, because I had to, to renew it not that long ago, they'll get it right to you, no problem. So in this state, we don't have these problems, but obviously there are still 8 states where there is a substantial division in how those rights are treated, and this state has a far different approach than, say, New York and New York State. And so the Supreme Court of the country needs to settle sort of that question, probably, because the division there is tremendous.
So you had mentioned before some specific cases in Colorado. Were you talking about in general specific cases, or were you talking about actual specific cases that have been argued or are in the process of being decided?
So I have to think now. I've got one appeal running on exactly this issue. I don't think I have any others right now, but this sort of issue under both menacing and disorderly conduct comes up repeatedly, and depending on where you are and what city and jurisdiction you're in, they're treated, sort of differently. So I have a specific case on appeal now that will be impacted by this case, Corlett. I have to think now what else I've got running.
So this is not something I come across all of that often with my students. I don't know how often it comes up for Edgar, but that is not something I encounter very often. So I don't know if you can provide some generalized examples of how this has happened for people, maybe not your clients, but just cases you're aware of.
So firearms type cases?
Specifically the menacing and brandishing.
Oh man.
Maybe start with the most egregious example you know of, because I think people would be interested to know that.
Okay, I have to think about what I can tell you and what I can't tell you about some of my most recent cases. So I can talk about hypotheticals.
Okay.
Hypothetical is if you have a high capacity magazine and you don't have a receipt or a sticker with you taped to the magazine to prove that you owned it before 2003, you're going to get arrested. You're going to get arrested when the cop comes across you.
Now let's keep this in hypotheticals. Under what circumstances would the cop come across you? Would this be a coincidence where you're running around shooting at people on the street, or would it be I was driving to the gun range?
I was driving to the gun range. The cop stopped me. He saw my case in the back of the car. He was concerned and said he would need to, secure or search the weapons in my vehicle, and asked me to step outside the vehicle. And if you agree, he's going to get inside the case. That's the clearest example. People want to be cooperative, and they want to explain either they have the CCW permit and the firearm on them, or they're on the way to the range and they actually do have a weapon in the vehicle.
Okay.
Because it's a standard question they ask you at a traffic stop. Do you have any weapons in the vehicle?
Okay, can you help me clarify something? Because somebody asked this question the other day, and I realized I had never considered this before. A police officer has a right to disarm you during the duration of a stop for his own personal safety.
Right.
That's under the concealed carry law.
Yep.
How would that apply to other weapons in the vehicle that are not? I mean, nothing in the car should be considered concealed under the law. No handguns should be considered concealed under the law if they're in your personal private means of conveyance. So under what context could the police officer go poking around in your car to disarm you? Let's say the weapons are in plain view.
So the way this unfortunately comes up frequently, unfortunately for me, is vehicles driving on the road, high risk stop ensues. They decide the vehicle looks like some other vehicle they're looking for, or a vehicle that was reported as stolen, or it's federal on a Friday night in the summer and it's just getting dark and they decide to pull you over for who knows what reason. But I've got people pulled over all the time. Tint on your windows. Federal Heights and some of the smaller municipalities will pull you over because they believe your tint is too dark. And once they pull you over, they're going to ask you the standard question about, do you have any firearms in the vehicle? Because they want to know. Or they're going to say that they saw a furtive gesture when they pulled you over and their spotlights showed that the passenger put something under the seat or bent down or wasn't in view the entire time. And they're going to want your hands on the dashboard while they shine their flashlight inside the vehicle and look. And if there's anything looking like a grip, anything looking like it is a muzzle, anything in the vehicle looking like a round, over and over again, I have guys pulled in because the stop starts almost the stop and frisk starts almost exactly like that. And then once they have the smell of marijuana or the smell of alcohol or anything else in the vehicle, or they believe they have a reason to get you out of the car, they have a reason to frisk you. And once they have a reason to frisk you, if you're going in, they're definitely searching that car, definitely inventorying that entire car. If you answer the questions the wrong way and they believe you have something in the vehicle that may be a weapon, they're definitely getting into that weapon. They're definitely going to look it over. And those high cap magazines are a favorite.
Yeah.
Suppressors are obviously a favorite.
Possession of a firearm in the vehicle is not probable cause to search the vehicle.
Nope. But officer safety will justify it.
But officer safety justifies it.
Search, officer safety, inventory search.
All right, let's set aside the gun for a moment and just say during the search, during the disarming of the person, they happen to come across paraphernalia or some other criminal type object or piece of evidence, or not evidence, but item. How is that not? I mean, the magazine to me would seem to fall under that. But of course, it doesn't matter what I think. But I'm just trying to understand this. That would seem like it's just a gateway to an illegal search that could easily be justified by officer safety.
Now, let me ask you Well, was that a statement or a question?
It's kind of like a meta question, I guess.
Okay.
So you're right. They can eventually overstep to where you can suppress some of the results of the search. And if they have to go into the trunk to unlock a case in the trunk to then search for the high cap mag that they eventually charge you with, that's going to be more of a problem.
Okay, but if the
Um,
high cap mag is in the gun, then you're going to have a problem
or if it's in a case in the trunk
with
locked
the
up
gun.
where they eventually get it. Yeah,
Mhm.
exactly.
Okay, all right.
So then, and this is tough, right? Because it all depends. That's the problem,
It all
right?
depends.
It all depends. So everybody wants, and I'm doing what my students do, and I get that, and I understand that because we all want a concrete, like, give me an absolute, but the reality is, it all depends.
Right.
So, according to the Supreme Court, a reasonable stop for a reasonable suspicion, which at this point is essentially just a consensual conversation with the officer, is about 20 minutes. There's no like 100%, but
No
it's
bright line. Yeah.
correct. Yeah, absolutely. But reasonably about 20 minutes is, I think, if I'm not mistaken, part of the Supreme Court ruling there. So, I mean, at what point do you just, because there's taking video, there's doing this, and there's kind of deviating questions, like there's nothing illegal in this vehicle, that type of stuff, which kind of raises a little bit more suspicion with most cops that are out there than anything else. But you're still well within your rights. So at what point do you like push in that, like, it's because of you that we're delaying this, and that's why the 20 minutes is now 40 minutes, and where's that fine line of I'm not going to give you the answers you're looking for by calling my attorney while I'm on a traffic stop.
Right. So the question sort of is, how do you treat a traffic stop when you believe you're being detained unlawfully? It's difficult to say when that line is crossed.
Yeah.
But there's a couple of bright line tests, and the primary question is, am I free to leave?
Yeah.
Because if you're free to leave, you can stick the key back in and go. If he says you're not free to leave, there's usually a couple things that go along with that. Number one, he's still got your ID, and he detains you by keeping your ID from you.
Which, by the way, in Colorado, we don't have to present.
Oh, I don't know if I agree completely with that, because the demand for identification is actually something that I think is established by at least one case.
Yeah, but okay. I'm just going off of what the state law says about that. And
So a consensual encounter can include a request for identification and an explanation of your conduct. Where are you headed? Where are you coming from? Simple, brief, temporary questions that do not unduly intrude on your progress and travel.
I'll have to look this up, but if I remember correctly, your ID is only required if it is available.
Oh, yeah, that's probably true. But if they ask, who are you?
Oh, yeah.
And you give them a name and give them a name and date of birth, it's got to be your actual name and date of birth.
Correct. But your physical ID, you don't have to actually present.
You don't have to have that on you. Because they can attempt to identify you, and they obviously run you for warrants as long as they have your name and date of birth, and they reasonably believe you to be the person you identified yourself as. So yeah, that's all true. Yeah. What usually turns a stop into something more than consensual is, let's say, maybe 20 minutes. More importantly, let's say he's got a hold of your ID and won't give it back. Well, you can't drive without your license in your hand. So if he's got your license, you're not leaving. If someone blocks you in, and officers used to, do this, I think, a little more often than they do now, but they block you in. One officer in front at an angle, one behind you, so you can't get out. If you are dog sniffed, if there is more than one officer there, if you're taken out of the vehicle, if you're cuffed at any point, if they have your keys, anything like that.
Oh, you can continue. I just wanted to put it up just because it was. So a peace officer may stop any person who reasonably suspect of has committed or is about to commit a crime,
Mm-hmm.
and may require him to give his name and address, identification if available, and an explanation of his actions.
Mm-hmm.
Yeah.
Yeah. Good. Good. Identification if available. That's exactly right. So those sort of, temporary stops have got to be temporary, limited in scope, not a general search. He's not digging through the glove box. He's not in the trunk. He's got a couple of questions. And the favorite question is, do you know how fast you were going? And you all know the answer to that is, don't you know? Because the wrong answer is yours, right? You don't say, no, I don't know, because then you're stuffed. And you
Yeah.
don't say, yes, I do know, because he's going to say, well, it's 10 over. So you don't answer either one. Officer, I'll be cooperative, but my lawyer on a podcast one time told me not to answer any questions, especially trick questions like that one. Right?
You're trying to trick me.
I've
Right.
actually, I think in my life I've gotten 4 or 5 speeding tickets, and I have never once been asked if I knew how fast I was going.
Good.
It was, hi, can I get your driver's license, please? Here you go. All right, I'll be back in a minute. Here's your ticket.
So I'll tell you what happened in Denver while I was still in law school was, and this was an officer I ended up cross-examining later, so I knew what he was doing. So he pulls me over, and I got this, cruddy Ford Bronco that I'm driving, and he asked me for a license and registration. I have it all. I hand it to him, and I had a pen in my hand, and I drop it. He says, "Oh, I'll get that," and he pulls open my driver's side door to reach under my seat and look under my seat. I'm like, you slimy so-and-so. I didn't even see it coming. I didn't have my door locked or anything, but he just pulls the door. He didn't wait for me yes or no or anything. He just pulls the door open and says, "I'll get that." And he got to look inside the vehicle. I realized that must have been a common thing that he learned from the other cops, because his badge number wasn't that old. And I realized he probably was doing that all the time. And so when my clients were telling me this guy just, popped my door open to look inside my car, I realized that's the guy that we're talking about. It was either that guy or one of the guys in his unit that was doing that commonly.
Huh? How about that? Another reason to keep your doors locked.
Yeah, yeah. And when they ask you, so I don't know that you can do this, but I've heard that officers, when they have had a few recreational beverages and they're stopped by a different department on the way home, they roll the window down a 1/4 inch and they slip the license and registration through that 1/4 inch, and they keep the door locked the whole time, and they're like, "Here you go," and then they roll the window back up. And that's how they deal with other officers pulling them over.
I've seen people do that. People videoing themselves. I've seen a lot of people do that. I've never actually seen anybody get into trouble for that move. So, I don't know. It could just be an officer doesn't know what to do. I have a hard time believing that they don't have a strategy for dealing with that.
Yeah,
my favorite one was this guy who was staying in a motel room.
Mhm.
He was in his car and he's eating like oatmeal, like hot oatmeal in a cup or something, and somebody calls the cops on it. He's a black dude, and it's late. It's somewhere in the Midwest. And they come up to his car and they're asking him to open the window and open the door and everything. And he just takes his license and he puts it up against the glass and he just holds it there. And they're like, "Sir, can you please step out?" And they just keep talking. And he doesn't say a word. He just keeps eating his oatmeal. And he's got his camera, but he's not actually talking. He just photoing the police officers, and he's just sitting there eating his oatmeal, and they keep talking to him. And every time they ask him to identify himself, he just puts his ID on the glass.
Awesome. That's awesome.
So now the problem with that at a certain degree is, because I hear of a lot of people doing that stuff.
Mm-hmm.
Is at what point do you, because you kind of have to invoke your Fifth Amendment um, in all of this
Ironically.
stuff. Yeah, you kind of have to invoke. Yeah, ironically, you have to say that you're not going to say anything.
Mm-hmm.
So, at what point do you think your rights are being violated, but because you didn't actually invoke your rights, continued the investigation process because of it? Because part of and obviously you're here to correct me, but part of the 20 minutes that they have is to investigate the issue, right? Like, why did they call this? They called us out for this. So that's the reasonable suspicion part is I'm trying to ask you questions. Once you've answered my questions, and I have no reason to continue my investigation, and then I don't have any probable cause, but you not invoking your fifth could potentially lead to the probable cause to begin with.
Right.
It's like, and that's kind of the fine line that I speak of, is just like, where's that fine line?
So the same thing applies to, being in the interrogation room for hours, or being on the side of the road, or just, walking along minding your own business and coming across a bike officer. If you don't seek to terminate the encounter, they can keep talking to you, because you're waiving any rights you might have if you just sit and jabber. And so the primary question is, am I free to leave now? Because I really am in a hurry, left the gas on at home. If you don't seek to terminate it, they can keep going. The second thing is, if you want to cut the interview off, you want to stop answering questions, you can tell them, my lawyer told me to remain silent and not to answer any questions other than ID and sort of general circumstances here, but I'm not to answer any other questions according to my lawyer.
Yeah.
Ultimately, what you have to use is the word lawyer, because if you don't tell them you want your lawyer present for questioning next, they again can keep asking questions.
Correct. Yeah.
So this is a form of, for lack of a better word, some kind of verbal judo here. You want to end the encounter saying as few things as possible.
Yeah.
But if you don't say anything, the encounter can go on indefinitely.
Correct.
They can keep on going. Like the guy eating oatmeal, they can keep on asking.
Correct.
You don't have to. You don't have to answer.
Mhm.
They don't have to go away until
But
you tell them.
that's kind
"Am I
of
free
the
to leave?"
dilemma I see a lot is people thinking, oh, me not saying anything is going to resolve everything. But again, part of the reasonable suspicion is we're asking questions here to try and answer the questions that somebody called us, said you were doing so and so. We want to make sure that that's not the case, or in some cops' case, make sure that is the case, because I get a hard on for arresting people.
Right.
And then the other thing is the pat downs too. I see a lot of people getting, oh, that's against the Fourth Amendment. And although I may agree, but I mean, you got the Terry versus Ohio, and that's kind of the big one in every state. There's a stop and frisk state.
There's
Every
definitely a
single
stop and frisk in every state. That's right. And so, it's important to know what to say during those encounters, because all of us end up coming across officers at one time or another. And it's important to know what questions to sort of avoid, but it's important to know what you can tell them. And what you can tell them is, I want my lawyer present for questioning. I need to know if I'm free to leave. Alternatively, I need to know if I'm under arrest for something.
Yeah.
Or you could ask, what are you investigating me for? The only real limit on their power to keep on going is you, or they discover that whatever they were pulling you over for was just in fact not the case. And the best example is a temporary license plate that's a little schmeary or covered in snow, and they can't see the expiration date, so they pull you over to confirm it, and by the time they walk up to your window, they already know that you did nothing wrong. And that can be clarified in one question: what are you investigating me for?
Yeah.
And they tell you, I was wrong. I thought your license plate was expired, but it's not. You're like, am I free to go?
Yeah, I've had a
That's
couple
the
of
next question.
stops. I've had a couple of stops where I was pulled over for something that was not illegal. It was, I had a tail light that was broken, and I had legal fix-it tape on the light. So the light was not in violation of the statute.
So the lens was broken, but it was still amber.
Right. It was still amber, and it was covered with the right color tape, so it still appeared the right color. It was tail light, so I got pulled over, and the police officer said, I pulled you over because your taillight's broken. I said, oh, I thought that the tape was a valid fix for the
Mhm.
light. He says it is, and I said, well, did the tape come off? He said, no, it didn't. I said, well,
What are we
What are we
doing
doing
then?
here?
yeah,
Uh-huh.
and he was fishing for a DUI. And so, and then I had another instance, and actually Edgar was with me. I got pulled over for the same thing twice. Edgar was with me for one of them, and that was the registration sticker on my car was not current. However, the registration itself was current. I had current registration. I didn't have the correct year sticker on the plate.
And
And in
go ahead.
yeah, and the cop told me he could write me a ticket for that, and then I didn't disbelieve him, but I knew the car was registered. So, in the first instance, I told him, I go, yeah, I just don't have the sticker. The plates are valid, And he went and ran them, and then he told me have a good night. The second time I was with Edgar, and he asked the question, "Where are you going?" And normally I don't want to answer that question,
Mm-hmm.
but we were going to our own gun store.
Oh, okay.
And we had pulled up in the parking lot right in front of the gun store. And so when we told the cop we're going to the gun store, this is our gun store, we own it. That was the end of the interaction. Now, have a nice night, So I mean, I had a cracked windshield too and a headlight out, and I didn't get a ticket for that.
Yeah, cracked windshield's a good one, or obstructed windshield. If you
Mhm.
have so much as a little evergreen tree hanging down as an air freshener, that's an obstructed windshield to some of them.
Mhm.
That's where I keep
But-
my gun, just on the windshield,
And
just
the windscreen back and
Yeah.
forth.
on the mirror.
Yeah.
Somehow having a laptop on your dashboard is not an obstruction of your view. I'm not sure I understand that one.
So registration's a really famous one because the month that it expires, sorry,
You have a grace month.
you have a grace month after the month displayed on your plate, and they'll
Mhm.
pull you over the following month and tell you your plate is expired.
No shit, Sherlock.
But they should know by now that you have a grace month to renew that registration because it's good for the 30 days after.
Oh, no. They're just trying to help you out.
Yeah.
That's what
Right.
they always tell you. I just want to let you know your plate's about. I've had it happen more than once. I just
Yeah.
want to let you know your plate's going to expire. You need to get that taken care of.
Yeah.
So
Yeah.
thank you for stopping me on the side of the highway,
Right.
for my own safety.
Right.
So I want to get back to the magazine question because when this law first passed in July 2013, well, when it was first put into place in July 2013,
Mhm.
there were a number of sheriff's departments across the state who said they were not going to enforce this law. Those are sheriffs; those are not state or city police; those are sheriff's departments.
Right.
And I remember it made big news when a guy up in Longmont or Loveland, or maybe it was Fort Collins, got arrested. He was possibly planning some kind of an attack on somebody or a group of people, and he was discovered and he was arrested and he was charged with the magazine ban. From what I understand, it was partially self-admitting, that he got those magazines illegally.
Okay.
And that was kind of like the big moment where, like, oh my God, finally somebody got charged. And I think it might have been a year or two after the law went into effect.
Mm-hmm.
And since that time, there's been a few publicly profiled cases with people who have had large capacity magazines, and they made it into the news.
Mm-hmm.
It seems to me, from what you're saying, though, that this happens more often than people know about.
I think so. And I think so for one specific reason. And I'm trying to think of the prior case I had, but I've had a recent case where a faulty arrest for a high cap magazine led to seizure of the weapon, and then the police department doesn't want to return it, and you have to get a court order or a release from the city attorney or county, district attorney, and that takes forever. And in the meantime, they try to destroy it, or you have someone with a felony conviction. They're driving their truck with their girlfriend. The girlfriend owns a firearm. The police pull them over for some other reason, and they seize the firearm because it's in his possession constructively because he's driving the truck. Or woman asks a guy to come with her to an exchange, either getting a car from an ex or getting some belongings from an ex, and he brings a firearm, and the ex, of course, notices the firearm and immediately complains, and eventually that case is dismissed because the guy didn't display it, didn't try to alarm anyone, kept it in the holster the whole time, blah blah blah. But they seize the firearm in the meantime, and they want it. The police department wants to keep it, and they destroy it before you can get it back. That stuff is fairly common, and I think the idea is to reduce the number of firearms. I think that's the policy behind it. I don't know if it's expressly stated anywhere, but I think that seems to be the policy, is to limit firearms on the street by just destroying them and seizing them when they can.
And I hear that a lot from students, that they catch a minor charge, and either it gets dismissed or they get convicted, but the charge doesn't require for seizure of a firearm under the statute, but they already had it in evidence, quote unquote, and then a year later, like, I don't know where my gun's at. I've been asking, and they don't know where my gun's at.
Yep. It's gone. It's gone by then.
It's gone.
And you only have a limited amount of time to file a civil claim with the city attorney's office, because there are statutes that bar claims outside of time, and it's usually only 90 days.
Yeah.
It's a real short time period to fight for it. And so but if you get your case dismissed, as before you leave that courtroom, you've got to get the judge to order return of that seized property, or you may not see it again.
So it's almost like some of these DAs then are using those little technicalities to, like you said, get rid of guns and backdoor gun control.
Yep, I've had them write it into plea agreements that they're going to destroy whatever weapons that they've seized as a result of either some mundane plea, or even as part of the dismissal, they'll try and avoid the question, thinking that'll just get destroyed, because they don't want to see weapons on the street and in private citizens' hands. Ultimately, is what the policy seems to be.
Are there counties and cities that are more likely to do this?
That's a tough question.
Because I mean,
I've had troubles in Denver, even recently in Denver, and so I'm hoping that's not some kind of trend.
It seems like from our experience with our students that Denver County is one of the more difficult counties to deal with when it comes to specifically property, guns, magazines, things like that. And I say magazines like getting magazines back and things like that. I did have a student who told me that she had her magazine confiscated up in Vail. I can't remember what county, Eagle County. I think it's Eagle County. She was pulled over. She was disarmed for the stop. The police officer gave her a gun back, but kept the magazine. And it wasn't even a high capacity magazine. It was like a 8-round magazine. And said, "Have a nice night. I'm keeping the mag."
That's different.
Yeah. So
I don't know that there was no charge or anything. He just
no. Yeah, just let her go. Just kept the mag.
That's called thievery. Ain't it?
I don't know that they can do that.
No. Of course they can't do that. Doesn't mean that they won't or didn't. Yeah. And she came to the class and she was like, she asked me, "Can they do that?" I'm like, well, obviously they did do that, but that doesn't mean that they're allowed to.
Would that be robbery?
Yeah, conversion or civil theft. Yeah, it's technically a theft because they've taken something from you with an intent to permanently deprive you of it, and there's no way to get it back because they probably didn't even inventory it.
Yeah.
Wouldn't the intimidation part turn it into robbery though?
Oh, potentially. Yeah, I guess, because he's armed and suddenly you're not.
Yeah, that's true.
So yeah, that's an interesting question. I've never heard of a cop trying to pull something like that.
Yeah, well, I mean, I don't know how much time you spent in Vail, but the cops in Vail are assholes.
Oh man, okay.
They have a noise ordinance on the fucking interstate when you're going through Vail, so that tells you something right there. Like, you're not allowed to make noise when you drive through our state, through our city.
Yeah, right.
So
engine brakes, anyone?
Yeah. So I have students all the time who are concerned about the high capacity magazine ban, and what I always tell them is like the law states that the law is concerned with how you got the magazine in the first place. There's nothing under the concealed carry law that states what you can and cannot carry in your gun. And I try to leave it at that. I try to leave it up, like, you may end up having to justify how you got the magazine,
Hmm.
but you will never, under the law, need to justify what you were carrying unless you acquired it, illegally. But you had made a mention that there have been cases where where clients or people you know of
Mhm.
needed to make that they did not have that justification handy, like a
Right.
receipt taped to the magazine,
Yep.
and then were ended up being charged with that crime.
That's right.
When that comes to actually arguing the case, isn't it on the state or on the local jurisdiction to prove that you got that illegally?
So if you look, and this is one of the things I was going to talk about under correlate and menacing and disorderly conduct too. It's just an affirmative defense, right? It's not an absolute defense like make my day. It's not even a strong qualified defense like defensive premises. It is an affirmative defense. And so by affirmative defense, that means you're arrested, you go to jail, and then when you get to trial, you can present this affirmative defense of yours, and they have to beat it. They have to beat the defense, not just prove the charges, but they also have to prove that the defense does not apply. So it's let's call it a great defense. That doesn't mean you don't get charged, jailed, booked, bonded, monitored on pretrial for 9 months, go to trial, sit in front of a jury, hope that they, you know, agree with you or at least don't strongly enough disagree with you that they can overcome that defense. And that's the problem with that is the officers don't even ask you when you got the mag. They don't on a lot of my cases. They don't even bother asking. And if they don't ask and you assert the affirmative defense, they really don't have a response because they never even inquired or investigated about it. And that's the problem with setting these things up as defenses. Self-defense. You've got a self-defense argument in a lot of confrontations, or at least one of you does, right? But if the officers don't investigate and look into it a little bit more, they either arrest both of you and one of you is supposed to go free, or they arrest the wrong one,
Mm-hmm.
and it's up to you to set that guy free. And that's the problem with sort of looking at these things like fundamental rights to carry a firearm, to exercise free speech, to maintain the privacy of your own home or your own vehicle. Those sorts of fundamental rights that you have under a constitution are supposed to be inalienable. They're supposed to belong to you. They're not supposed to be just defenses, because defenses already mean it's too late. Defenses mean you got to hire a guy like me. Like defenses
Yeah.
mean that you're already sucked into a system that can spit you back out without a lot of oversight.
Yeah.
That's the problem with that approach. And so that's hopefully where we get with something like correlate for personal carry outside of your home. But in Colorado, everything comes down to what kind of affirmative defense you're asserting, including self-defense whenever you even just display a firearm or use any kind of force against somebody. And that really mistakes how that should be analyzed up front, day one.
Okay, so let me ask a practical question then.
Mhm.
You get pulled over or otherwise stopped,
Mhm.
and they find some illegal high capacity magazines.
Mhm.
You get cited. Let's not even talk about arrested or
Mhm.
whatever. You get cited for it.
Mhm.
You have
Well, summons would be technically an arrest, right?
No, summons means you're released on scene with a future court date. So
Okay.
it's just the same as a traffic ticket or a civil
Okay,
summons
got it,
where you
got
got
it.
a court date. That's all that means.
Because you'd be summons for this one, right? Because it's a criminal case. It would not.
They would typically not arrest you, although if they're going to seize the firearm and make a big deal out of it, you'll
Yeah.
go to jail on it. Yeah.
Okay.
It's all semantics, but it just words matter when it comes
Yeah.
to.
yeah. It's not
Yeah.
semantics when the handcuffs are clicking around your
Yeah,
wrist. though.
yeah, that's different. Yeah.
What semantic does this fall under? All right, so we get to the point right before a trial.
Uh-huh.
What is the likelihood that they're going to proceed with this charge when you have made it clear that you have an attorney and this is the route you're going to go is you're going to fight this charge? Are they likely to even try to take that to trial, or is that going to be like, yeah, okay, you're right, we're not going to try to prove you didn't buy this magazine prior to 2013?
Okay, so let's talk legally, and then let's talk practically. So legally speaking, if you've got a solid defense, you got evidence to support it, you've tried to show them, some limited information about that to
Let me
convince them
stop you
they should.
right there, though.
Yeah,
The statute doesn't say that you have to prove you got it before 2013.
that's true.
So why would I have to prove that I got it before 2013? Why would I have to show a receipt? Wouldn't it have to be that they need to show that I got it after 2013? Wouldn't they need to provide the evidence and convince, a
That is
grand jury or
exactly
yeah,
how it's supposed to work. But
supposed
to
to?
to save your guy thousands of dollars for a trial date, what you want to do is get rid of that case as early as possible, and so
Okay.
you end up, if you don't have a receipt, you establish that the guy's got a history with firearms, has had firearms for at least as long as the statute's been around, has had long guns for that time period, for example, and has been to the range over and over again, or had a military history, or was a former, LEO, or something like that. So you establish a history and a background, and you assert that the magazine, although you've got it in evidence, doesn't have a serial number, doesn't have a receipt taped to it. There's no way to prove that he bought it after, and no way to necessarily to prove he bought it before. But we can prove a history of ownership of exactly the weapon that magazine fits into, and that's really the source of the defense. And if you decide, I mean, it's a tactical decision, right? It's chestnut checkers. So you decide you're going to share that with a city attorney or a DA beforehand, and if you trust them to make solid decisions based on the information you give them, then you might choose to do that, and you try to convince them that this is a loser dog and they want to get rid of it.
Okay.
If, however, you're in some counties, here's the practical end of it. Right now we've got speedy trial problems across the state with all the criminal trials piling up, and you can get better offers, or trials are not going to proceed on the dates that they're originally scheduled, or even 9 months after they're originally scheduled. And so you've got sort of a practical consideration about whether you're proceeding to trial or not. That's something that we look at, really deeply now. Or you have a DA who just will not will not entertain anything that you've told them, will not look at the case, will not understand your view of the facts, just will not see it from your point of view. I had a trial 3 weeks ago. I won it in 15 minutes. The jury was out. They came back in. They were done. They were probably done the first day, to be honest. It was a dumb case. It shouldn't have gone to trial. Shouldn't have wasted that time. We shouldn't have brought the jury in. It's the end of a pandemic, granted, but we shouldn't have put people through that kind of risk. But it took 2 DAs to lose that case, and my feeling was they were one was training the other, and that's what that case was about. It was a training day. And so, practically speaking, they made a decision they were gonna run that thing no matter what I told them, and that's what they did, and they lost. It was embarrassing. It was dumb, but I get that all the time. You get cases that just have no foundation, and they run them anyway. And I can go on and on with stories about how bad that can get, but they don't have to play fair. They don't have to play on the same level as you. They don't have to follow the same rules. They are not held to the same standard. The judges have definitely see them every single day, and they don't see you except for that trial. And so you've got a different different hill to climb than they do every day. And you walk in and you're the out of towner, and they don't have to treat you like their peers. And that's what you end up with as a trial attorney, is you play the hand you're dealt, I guess. But jury trials should not be lost in 15 minutes. But that jury was done. They had it, like they were, and it was silly. It was another sort of self-defense type case that was clear, but not to them.
Mm-hmm.
That's crazy. So one thing that I posted up was, and I don't know how relevant it is, but a letter for the magazine ban, the technical guidance on the interpretation and application of House Bill 1224, large capacity magazine ban. This was, I guess, quasi-commissioned by Hickenlooper, which was then to be written out by John Suthers, who was the AG at that point, for those that don't know. Like, how much weight does this have with the law, because it basically clarifies a few things and it defines what a large capacity magazine is. Doesn't, and in essence, change the law, but it clarifies.
I
it.
would say when the law is subject to some interpretation, they will pull through the legislative history and other definitions to come up with a reasonable memorandum that gives their view on how that law would be interpreted, because a lot of these laws end up with plenty of room, plenty of gray area
Yeah.
created by the way the language is finally entered into the record. And so I think that is guidance. I don't think that's the final word, I guess is
Correct.
what I'd say.
And
I
I think
think,
it explicitly says that this is not meant to
yeah,
override the law in any way, shape, or form, but
Right.
it's a complementary thing.
yeah. And in court,
Well,
you
if it
could
was
use
so
this.
complimentary, why didn't they put it in the goddamn law in the first place?
Right, exactly. And why didn't they? And so one of the things we use to guide ourselves when we're reading through this stuff is if the legislature intended a specific result out of any sentence or a word in legislation, they would have put it there. And if they left it out, we have to assume that they meant to leave it out. They got a room full of guys in the basement at the legislature writing this stuff, and they're not dumb guys.
So
And so if they
when
leave it out, it's on purpose.
Edgar and I tried to, we successfully filed a petition with the Secretary of State to remove the federal language from the concealed carry law as far as marijuana use. So,
Oh yeah,
in effect, we were striking 2 words from the law. That was, if I recall, Edgar, that was the extent. Just striking the words "or federal" from the law.
Correct.
And the hoops that we had to jump through to get that done. I was like, wow, they're really thorough. Well, they're only really thorough when it's the citizen asking for permission.
And we were using you have to go through the same attorneys that the legislature goes through when you're doing a petition, because you're going to put it on the ballot. So you use the same office of attorneys that the legislature uses, and yeah, I mean they're not retarded.
No.
But I think the biggest thing is they're dealing with people who are. So it's just like they're
including legislators.
No, and that's exactly what I meant by that.
Yeah, that's what I thought you meant.
Yeah. So I think they're like, how do we word this that doesn't sound so retarded? But like what you gave me is pretty retarded. Like it's
right.
like it doesn't make sense.
Well, here's and this is my interpretation. The catch-22 about writing law is the more specific you make it, the less effective it becomes, and the less specific you make it, the less the more confusion it creates. And so there is a balance. There must be a balance at some point between that level of detail. Unfortunately, that also leaves the interpretation of the law up to unelected bureaucrats in a lot of cases, and that is a tyranny in and of itself. I mean, Edgar, makes it clear that any government organization that you didn't submit to is a tyranny in and of itself, and you can make that argument. But I think it's a stronger argument to say that bureaucracy is a tyranny in and of itself. And when you have a law so poorly written that is interpreted by the AG at the time as the only existing guidance for that law, and it's 3 pages long, and the law itself is what, I don't know, from memory, maybe 12 to 15 lines, and we have a clarification that's 3 pages long. How is this fair to the citizen? Because how is the citizen expected to, let me just go look up what the attorney general wrote up on this and use that as a guidance that's not been approved by the voter or a legislature, never been tested in court, and somehow is supposed to be my guiding light.
Well, I think it was Jefferson that said something like, governments eventually evolve into tyranny. Like that's just the eventual. And the same thing applies to every bureaucracy and really every policymaker that wants to interpret something like a law on high cap magazines. They will interpret it more favorably than, for example, you or I or the most of the populace, and so it will move towards more restrictive than the and means that are they're more authoritarian than what the original legislation even read like. And I can give you plenty of examples, but if you want to see an example of a government moving more towards tyranny and away from the letter of the law, you look at all the exceptions under either the Fourth Amendment to the federal Constitution or the
Yeah.
Article 2, Section 25 of this Constitution, and look at the case law under something as simple as the Second Amendment, which has maybe 15 or 18 cases under it, and then something like search and seizure law, which has a laundry list of cases underneath it with all of the exceptions they've crafted over time.
Many of
And
which
so,
were written by conservative justices.
yeah, and crafted and created, sometimes with what looks like just whole cloth, creativity, just
Yeah.
Yeah.
made that stuff up.
If I'm not
and-
mistaken, Clarence Thomas is one of his few opinions that he wrote. One of them was a Fourth Amendment opinion that was under the law, the War on Terror was a drastic expansion of the fourth of the government's right to intrude on the Fourth Amendment.
Right.
And it was I'm not a constitutional scholar, but Clarence Thomas doesn't know how to write a justification. yeah. So and I remember reading the decision and I was just like, well, there's the end of that. That's the end of the Fourth Amendment right there. Especially I don't want to stray too far from the firearms topic, but this is an argument I've been making for nearly 20 years, which is the further we expand these powers of the government, the further towards unpredictable outcomes we get. And the last 12 months should show conservatives why it was so retarded of them to support this war on terror in the first place.
Right.
Because now these decisions, these Supreme Court decisions, these bureaucratic decisions are being turned against them, as exactly every good real liberal would have argued at the time.
And for us as the citizens, and this is one of the things that I urge people to do a lot, and I'm sure 99% of the people who listen to it, because it falls on deaf ears, actually hear it. They actually accept it. Is you have to nerd out on Supreme Court rulings. You have to nerd out about case law, and you have to read all this stuff because it's getting to a point where if you're anything like me or even a little bit like me, you're going to try and push it to the edge as much as you can, understanding that you live in the world that we live in, right? Somebody who loves liberty is constantly walking that line of, I'm about to commit a felony, allegedly. But
you mean like by going to the post office?
Just going to the post office, not having enough stamps.
Yeah, stamps. It's stamps. That's what it was. Yeah.
So I mean, you're walking that fine line all the time by doing stuff that doesn't have a victim. There's no victim involved in this process. But you're constantly doing this stuff. But I find that people are ignorant to what the law says, and then they listen to everything that is said online, and they're like, oh, well, I already know what the law is. So, like, I'm going to go to the post office and then argue old cases that have been overturned, and everything's going to be just fine. And it's like, no, you got to understand, like, every facet of it. I mean, it baffles me that most people who understand freedom don't understand the simple one, the one everybody should know, Terry versus Ohio. Like that's a small one that everybody should know, and most people are like, I don't know what the hell that is, and they get mad because they were frisked. But then there's a way to navigate a traffic stop with all of these Supreme Court rulings or going to court or what have you. But like if you're ignorant to what the law is, then like you're fighting yourself from the beginning, and it's true what they say. You are your biggest fucking like you are your biggest enemy. You are on all facets.
It's very Kafka-esque.
Yeah, yeah, yeah.
Um, what is the name of that book? Is it The Trial? I think that's what it is. The Franz
By Kafka.
Kafka.
Uh-huh.
Yeah.
Yeah.
Yeah. If you want, like that book was written a long time ago.
Yeah.
But if you want to see the theory behind how bad things can get for you, that's a good place to start. It's a fictional book. It's not that long. If you dedicate some time to it, it'll take you maybe like 3 or 4 days to read it. And it's just this maddening in like loop of bullshit that this guy goes through.
Right.
And it's terrifying if you think of it applied, practically speaking, to people's lives. And yet it happens to people. I wanted to get your opinion, and I'm not going to mention any brand names. I want your unbiased opinion about self-defense insurance. So we're talking about companies that provide self-defense insurance for people who use force, not people who get pulled over for magazine violations and things like that, but actual use of force.
So for me, that stuff comes down to standard contract law. And I'll tell you why. I had the opportunity to read through a binder on one of those self-defense insurance policies. And it's really important to read through that, even just get an example binder or someone else's binder and read through the language before you agree to sign off on that stuff.
Okay.
Because my reading of some of those policies means they can deny coverage almost across the board if you're charged with any kind of crime. It looks to me like it's there to prevent against wrongful death or assaultive type injuries in civil lawsuits. But the real insurance you need is, how do I get out of jail? How do I get back home after I'm bonded? Who's going to pay for the cost of the lawyer after that? What's going to happen with my criminal case? But some of that stuff looks to me to be designed really for civil suits and not for the more immediate application to, do I get to keep my freedom or not? That should be everyone's primary concern for a self-defense situation ever. So when I read through some of the stuff in those policies, I was not impressed with the way the language described intentional acts and exclusions, criminal acts exclusions. It didn't seem to bode well for anyone trying to use that insurance for the real immediate concern of a criminal case. In terms of covering a civil lawsuit later, I guess it would serve just fine for that. But I don't think that's the primary problem. If you're in a self-defense situation and you've got to use a firearm, I don't think that's not going to be your main concern.
Okay. So putting aside the technicalities that could probably get them out of representing you if they didn't want to,
Mm-hmm.
A lot of people think that if anything ever happens, they're just going to figure it out. How important is it to have a plan for representation as a part of your daily life? Even if it's not a retainer, it's still a plan for representation.
Yeah, so that's like asking, do you have a plan for removing your own spleen? Without seriously, from
I do, by the way, I do.
Oh, see, I knew you would. But thinking it through, all of the stages from the time you even just pull a firearm and get a disorderly conduct charge, or you have a firearm on you and you get an argument because someone dings your door in the parking lot and they see the firearm on you because it prints through your clothes. But just, you really have to role play and get through step by step what's going to happen from the time I have some kind of incident where an officer is called. What's my reaction to the officer appearing on scene? What do I do from step one to step done? Because if you haven't played that through in your mind with someone with some experience to explain what you need to do at each step and sort of get a script going in your head, without having someone on your speed dial to call, without having a bonds person ready to go, without having uh, you know a box at home that says break in case of a with a glass face that says break in case of arrest. Like, without having something set up ahead of time, most people are just blindsided by what happens next. They're blindsided by how simple it is to get a charge. They're surprised by how poorly the system works. They're surprised they were arrested for something so dumb. They're surprised they have to sit next to me for 9 months in court until we get to a trial date. Like, all of that hits people in the face like ice water. And they keep asking me, is this how it works? Well, yeah, of course it's how it works. I know it. It hasn't made it a lot into you see on TV, you see Law and Order and CSI and all the police shows. You don't see the other end of it, right? You don't see defense shows. I think there's one coming out soon with a Law and Order theme to it, but you don't see what guys go through when they're falsely accused outside of just a few select instances. You don't see that explained. You do see stuff like, for example, the Innocent Project out of the University of Chicago, where they've got hundreds of people exonerated over the course of time. I mean, there's just a news story this week about some guy whose DNA was not on the murder weapon, but they killed him 4 years ago.
He's dead now. Yeah.
Death penalty. Wrong guy. Oops.
But if you're Edgar, you'd be just happy to be right, even if you were dead.
Yes.
This is the best way we can honor Edgar. You were right, dude.
You were right, dude.
And then switch out the tombstone to say he was right.
Yeah, seriously. I mean, people can't be surprised by if that's how poorly the system works, is a death penalty case. And so you understand, a death penalty case runs its way through probably a team of 2 lawyers, a team of paralegals, a couple of investigators, and 1.5 years of litigation before you ever get to a penalty phase. Then the appeals start at the state level, and you go, trial court, motion for new trial, Court of Appeals, Supreme Court. Then you go back down and you start the ineffective assistance appeals on, challenges on habeas, and you go trial court, Court of Appeals, Supreme Court, back down. And then you go to federal court and you start your habeas proceedings and direct appeals to federal court, and you go district court, Court of Appeals, Supreme Court, and you come back down. And after all of that review, we still fucked it up.
Yeah. Yep.
How does that how can that happen? And the answer is the system doesn't work very well, and the procedures that we still follow in the law are still mired in some of them in really ancient doctrines that have no applicability anymore. The evidence rules, some of them are 200 years old, and they just don't work well with for example, technology and cell phones and body worn cameras and social media and all of those things have taken the legal system by surprise.
Yeah. Which is weird. I mean, it's taken a while. We knew it was kind of going there, and it's weird. Something that trips up, and I've had to let students know just how fucked up the legal system is and how poorly laws are worded. Even in case notes, like if you read, I'm reading right now 1812-105 on what possession is. It talks about it's about the person, right? And I'm gonna try and put it up here, and that's that means anything that is sufficiently close to the person to be readily accessible for immediate use.
Right.
And then if you read 1812-106, now it's in different context. I get it, but it defines possession in a different way. So even there, possession of a firearm. Oh, I'm trying to put it back up. Possession of a firearm, according to 1812-106. Where was it? Possession is the actual physical control of a firearm. So it's just like even the definition of possession, depending on the context, is going to be 2 different things.
Right.
Some of the people in our classes don't even have actual physical control of the gun. Under the way that we would define it, it's like, hey, you're not controlling that thing at all. I'm just using that as an example of how widely interpreted that could be. You know.
I met one of those guys actually. I know who you're talking about actually. Oh, so that actual or physical control comes out of a lot of other definitions in the law. So it's a sort of a common phrase they
but it's still
reuse.
possession. It's
They
just two
try to
different
recycle it.
contexts. It's
Yeah.
just two different contexts.
So you know that definition covers firearm in a safe, firearm in another room, firearm locked in the trunk. That covers an awful lot of things that you wouldn't think are either actual or physical, but because of other cases decided under other sections of the law,
Yeah.
that thing has been expanded beyond what you think is reasonable. And so,
Correct.
real common cases, a DUI, where actual physical control of a vehicle you would think would be a requirement. But the way they've defined that is if the vehicle could be put, if you're in the vehicle and it can be put into motion easily, then you're in actual physical control of the vehicle. So you can get a DUI parked. You can get a DUI when you're asleep.
You
You
could
can
be
get
a
a DUI in
responsible
your
human.
driveway.
You could be a responsible human being and be like, you know what? I am way too drunk to drive. I'm going to sleep this off
Uh-huh.
and still get the DUI.
Yeah. If you have the keys and you're
Yeah, that's
parked,
crazy.
that's enough. Doesn't have
Yeah.
to be on. Parked.
Yeah, I mean, personal experience. I decided to spend the night in my car one night in a parking garage in downtown Denver,
Mhm.
and yeah, I could have been
So by
arrested
all
for
accounts, a
DUI.
responsible decision, right? By
Right.
all
Where else
accounts,
was I going to sleep? Was I going to
Yeah.
like?
Yeah.
Like,
Because you're in public intoxicated, so you can't stagger down the street,
mm-hmm,
right? You can't sleep anywhere other than potentially in the car to be safe.
mm-hmm.
And the car's right there. So you lock yourself in and fall asleep. And yeah, actual physical control.
Yeah,
You-
and
you-
actually, we know somebody whose son was charged with DUI
Mhm.
in that exact same circumstance.
Yeah.
So
You felon.
yeah,
You felon.
and
Mhm.
and the thing is like, let's say best case scenario. I mean, obviously, getting arrested for DUI is not best case scenario, but it can happen. But best case scenario is you win the case. Well, it doesn't come cheap,
At all.
you know, and it doesn't come without its own consequences aside from the money. And it's a nightmare, you know, to think about. And it's a miracle that I've never run up against the law in this way in my own life.
Mhm.
It's a small miracle, and it amazes me that people take this stuff so much for granted, you know. And when we do our classes, I try to drive this point home to people as much as possible. I want you to be safe, and I want you to be trained, and I want you to be ready with your gun. But you know, make no mistake, you are opening yourself up to a huge amount of legal liability by participating in this right, you know.
Mhm.
And you can't predict what's going to happen if you ever do come up against the law.
That's right. That's absolutely right. You can't predict what's going to happen if you walk outside with it.
Mm-hmm.
Right now, you don't even know if that's a fundamental right in this state or any other. You know, according to the disorderly conduct statute, if anyone gets alarmed, you know, you don't have that right.
Well, yeah, I mean,
And-
I when I mow my lawn,
Yeah.
my lawn. I'm carrying while I mow my lawn, not because I'm mowing my lawn, but because I'm always carrying.
Mhm.
And you know,
Those lawnmowers get fucking crazy, dude. You never
Yeah.
know when you have to fucking shoot a lawnmower.
every other time I use it, and I'm just in my yard, you know. But there's people walking by all the time. There's people, you know, walking by. They've got their dogs.
Mhm.
I had an incident where my own dog got loose and went after somebody, and
Oh.
I knew my dog wasn't going to hurt them. I knew that she was going to chicken out as soon as she got near them, but they didn't know that, you
Mhm.
know, and they freaked out, and I would too. And their response, I would have responded the same way. They kicked my dog pretty hard, and I would have done the same thing if I was in their shoes. You know, I didn't
Mhm.
blame them for it, but man, that could have gone a lot differently. You know, and I'm just out doing the Saturday thing. You know, I'm just mowing the
Mhm.
lawn.
Mm-hmm.
Yeah.
Yeah. And that's why I think the training is so important for most people, and the education is even more important for most people, because at least in this country, we don't get a lot of government, we don't get a lot of civics, we
Get
get
zero
no
at this point.
law. Yeah, we get 0. And so there is not a lot of education on rights and responsibilities and what it means to be a citizen with certain inalienable rights, to understand the distinction between federal and state laws, to understand the distinction between laws and administrative regulations, and some of the things that govern something as simple as a driver's license, right? I didn't learn that in school, and I thought I had a fairly solid education, but I didn't really pick up what all that meant. And some of that stuff should be just part of what you know when you leave high school at the latest,
Yeah.
but potentially even sooner than that. Um, because you should understand what authority police have as opposed to what uh, rights you can assert and what things you can say to terminate an encounter that you don't believe is consensual, that you don't want. You should be able to refuse authority if you want to. And the lack of education means that you're just a passive participant in all of that because you don't know. And so ignorant of a situation is really vulnerable to it. Use of a gun, carrying a gun, uh, you know the stuff we go through in class, I think is people's first exposure to both the opportunities and the risks created by firearm ownership and possession.
Yeah. And that's the thing is like, I talk about this in my class. I'm pretty sure Edgar does in his classes too, is like, you want to yell about your rights all the time, and you need to understand what responsibilities come along with that.
Mhm.
I believe everybody has a responsibility to have some basic medical knowledge if they're going to hang around guns
Yeah,
all the time.
that's good.
We have an instructor who's taught out here at our range before, and he teaches medical stuff. And he had a student of his who used his medical knowledge for a friend who just shot himself while they were at the range.
Oh wow.
And he was like, "Hey, thanks for that information, man. It really helped me understand how to deal with that situation." It there's a lot that comes along with this, and people, I actually try to make people feel bad for just going to the gun store and just buying a gun and thinking, okay, all my problems are solved.
Yeah.
Like try to lay it on them like, hey, that's a stupid way to think about it.
Yeah.
That's not a responsible way to think about it. It's not realistic. And if you want to just waste money, like I'll take your money, like because if that's what you do when your plan for your self-defense is just go buy a gun, like that's a waste of money.
Yeah. That's exactly right.
So we had somebody comment. Let's see. Ryan said, "This has by far been your best podcast," which is kind of offensive to me. He said Brian should be on every episode.
Oh man. and there's plenty of stuff we could cover too, because we've got the pending laws in this state. There are other cases obviously moving through this state we could talk about. Some of the recent events, at least in the news. You can do a current events section that
yeah, by the way, 2 self-defense cases in Colorado Springs in the last 6 months, pretty clear-cut cases of self-defense. Both, actually, it's more like 8 months now, but both circumstances, the defendant or the good guy spent 4 months under investigation before he was cleared of charges. Both, and I think if I recall, you were involved in a case in Aurora where a guy spent 4 months under investigation.
Can't talk about it.
And completely
Allegedly.
justifiable self-defense, and spent 4 months waiting for that phone call from the DA saying, time to turn yourself in. One of them, interestingly, took place inside a guy's apartment, but was not castle law. The bad guy in that case was invited in, and then things went sideways from there. And
so he's an invitee. Yep.
He was an invitee. So the good guy in that situation had his face broken, literally. Wow. He had facial fractures from the beating he was taking before he shot the bad guy.
Wow.
And still spent 4 months under investigation for first-degree murder.
So I just really quick, I put this up on the screen just because Ryan asked, "What do you have to answer when talking to the cop? Just name and date of birth." According to 16.3.103, not even your date of birth or social security number It just your name and address is the only thing you have to give the officer. According to that law, obviously, if Brian wants to jump in on that, I have.
Go ahead.
Go ahead.
So again, there's the legal and the practical. The legal
yeah.
is they can only ask for your identification if available, and the reason they want that ID card is because it carries your date of birth or an identifier that they can run on a database back at the laptop in their patrol car, and they're clearing you for warrants. And so if you've got warrants out, that's what they're looking for. They screen everybody that way, and so that's why they're looking for that information. That's why they're always going to ask for your date of birth every time. It's important never to give a false name, because then you're providing false information to an officer, and that's a whole separate charge and not great.
I can tell you what the charge is. The charge is criminal impersonation. It's a felony 6.
And what is the penalty?
Well, if you plead it down, you're not going to do any jail time.
Yeah, right. Yeah, exactly. So that's the the legal part of it, and then the practical part of it is you're probably not going anywhere until you establish your identification to the satisfaction of the officer, and that's going to include your date of birth, because they want to run you.
And I just read here, and an explanation of his actions. So you have to explain what your actions are, whatever that means.
Yeah, I and unfortunately, no one's going to know what that means.
Correct.
It depends. I mean, explain your actions to me, sir. And I pulled over because
You're like, where do you want me to start?
You chased me, yeah.
I had an abusive father figure.
Yeah.
My mom was a junkie.
Exactly. Yeah.
I'm black. Systemic racism made me this way.
So I have a question, and I don't know if this will deviate too much.
Mm-hmm.
I know we're kind of winding down here. We don't want to keep you up too late, because I know you got to save people tomorrow and all that stuff.
Yeah, back at it.
But one thing that in self-defense, in the context of pew-pewing people, one of the things that I've started to really yell at students about is this idea of, listen, if you actually need to shoot a fucker, like it is an immediate need, that's the only thing you should be worried about. Don't worry about going to jail. Don't worry about anything else. Because I see students often hesitate in class, of course, because I haven't actually seen them when duty calls. But in class anyways, they seem very hesitant to even pretend to use deadly force in self-defense, because they're afraid of the consequences. The reality is there will be consequences.
Mm-hmm.
I mean, best case scenario, you don't go to jail, but every time you go look for a job, they type in your name and like, holy shit, you got arrested, or you were involved in a shooting, or what have you. Because that information is most likely going to be out there if you're in an investigation. I know one of our students who had to shoot somebody outside their house. You can type up their name and their case comes up, and like it's all over. It never went to jail, but there was an investigation and it was on the news and all that stuff. How do you feel about that as an attorney? It's just like, if there's an immediate need, really don't worry about the legal. I know it's kind of two different things, but I mean, what's your comments on that? If you got to shoot the person, do what you got to do. We'll worry about the legal stuff later.
So this is a really difficult and probably more complicated question and answer than you were expecting. But the situation that would justify you shooting would probably absolutely have to occur inside of your own home. It would absolutely have to involve an intruder. It would absolutely have to involve some element of probably surprise on your part that you've got an intruder, and you would have to be armed. And in that circumstance, if the person appears to be a threat and is not doing their best to flee, I think you're right. The split second it takes to do that kind of processing, the emergency thinking that goes on doesn't leave a lot of room for rationalization. So I still think you're right. If you're in a situation where you've got someone inside of your home,
Well, even
you
outside.
don't have a lot of choice.
Yeah.
Now, outside, you've got to think through a little bit more. And I, in the past when you've taught class, I've liked some of the examples you've come up with.
Yeah.
And I'll give you two of my favorites. One is, I think, a question from a student in a class one time where they asked, "What if I come upon a 7-Eleven that's being robbed?" And your answer
Yeah.
was, "How do you know they're being robbed?
Yeah.
How do you know who's doing the robbing? How do you
Correct.
know there's not an undercover officer standing there? How do you know it's not,
Correct.
something that you're not familiar with that you're walking into and you've got a firearm?
That
How do
sounds
you
very
know?"
smart, so it sounds like me.
Yeah, you said, yeah, exactly.
Yeah.
And so how do you know you're the white knight and not
Correct.
somewhat grayer than you think? Two, and this is active shooter situation. So in a school, in a
Correct.
King Supers, in any kind of situation where there is an active shooter, and we can all assume, for the sake of argument, that that active shooter um, is actually the bad guy. Is it in your best interest? Does it increase your risk of surviving
Correct.
to go after that bad guy? And the answer is probably not, because every study seems to show that it is time to turn tail and move, because if you keep moving, you will be safer. And if you keep out of the way, you have a better chance of surviving. And if you're at least running, you have less of a chance of being hit, uh, even by a good shooter, uh, but in particular by someone who picked the gun up, a week before. You've got a better chance of getting away if you're a moving target and running away and seeking cover, and using other opportunities than just standing there and attempting to go toe to toe with an unknown bad guy, likely with more preparation than you, better equipment than you, a longer gun than you've got, body armor where you don't have anything but a t-shirt. uh, those sorts of situations outside of your home um, present a whole new set of shooter decisions, and that's why police go through active drills all the time.
Yeah.
They've had video and virtual training for a long time now, and it's to prevent the sort of situation where someone downrange catches the round you thought was going to hit the bad guy,
Yeah.
and where you make the wrong decision and you get the innocent that happened to be too close. Those sorts of decisions outside of the home are far more difficult, far more complicated, and you're not safe just snapping to a judgment. Then the law in this state, at least, is uh, you have the ability to defend yourself inside of your home against an intruder, and the rest of the law around defense of premises, self-defense of others, when it comes to deadly force, is too complicated for a single podcast, unfortunately, and
Yeah.
that makes
Yeah.
it too complicated for a snap decision. It makes it too complicated for just easy training scenarios. It
Correct.
overcomplicates it, unfortunately, and that's
Yeah,
where
and
the
I think
law
that
becomes not useful.
yeah, and that's kind of the idea, right? Like if you genuinely believe that you're about to die and your only option is to shoot the
That's it.
individual,
hmm
then there's almost no way you can even process what 18.1.704 subsection 2 like
That's out
says.
the window. Yeah.
That's like completely out. But I think if you're like encountering somebody breaking into your car, you're like, I wonder if I'm going to go to jail, if I'm doing the right thing or not. Chances are you're doing the wrong thing.
Yeah.
Exactly.
Yeah.
You're like thinking about this
Exactly.
way too long, and you still haven't died. Like you're not
Mhm.
talking to Jesus right now. So clearly, you have enough time to get your ass back inside and call the cops and let them do what they're supposed to do after.
Yeah, we got a lot more to talk about. We're gonna
Yeah,
have
yeah, yeah.
we're gonna have to have you on again
We got a
because
ways. Yeah.
this is incredibly useful information. But I saw a poll recently taken on a very biased website about whether or not people think that these are all gun owners. People think that lethal force should be justified in defense of property, and it was overwhelmingly, it was more than 90% people said yes. And that's not surprising, but what that translates to is a lot of people who in that moment are going to make the wrong decision, and because they've already kind of made up their minds. And I don't care what you think ethically. I really it doesn't matter. But if you think you're not going to jail for something like that, you are sorely mistaken. And people don't think that it should be true, but that doesn't mean it's not true. It astounds me that people equate their feelings to what the law says, and how brutal the law can treat you when you think you were right. And you think you had a good reason. There's murderers on death row who think they had a good reason for killing the people that they killed. You want to see a good example of that? Look up interviews with Richard Kuklinski. That guy was a stone cold killer who had no problem killing as many people as he did. So it's really important that people spend time learning and thinking about this stuff, because we don't want this to happen, but we don't get to control if it does.
Correct.
We don't get to control when that moment of decision comes to us. And so it's very important, and it's good to get your perspective, because a lot of instructors would agree with Edgar on what he said based on its face. They'd be like, yes, I totally agree. But to get an attorney's opinion, like, look, man, if you want a solid open and closed book case, barricade yourself in your bedroom and make sure you're dealing with an unloaded assailant, or an unknown assailant coming at you. And even then, you're praying to God that you're not going to get charged with some kind of a crime. That kind of perspective is really useful, because as instructors, we're focused on experience as much as possible. And from an attorney point of view, that experience is invaluable. So
you guys want to wrap this up?
Mm-hmm. Yep.
Yeah. Let's wrap this up. I think this conversation is super duper important. I think we should have more of these conversations. Here's what I'm gonna shamelessly do. I'm gonna, and I'm doing this because this is super valuable. Brian has been an advocate of the Second Amendment for a very, very long time. He's helped numerous of people get out of some pretty sticky situations. And what I would like to do is for our, what did you call them? Our people, those on the comments to kind of help us out and throw some shekels over to Brian DeBush. We do have a link, but it's specific to the Larimer case, and I don't want it to be to the Larimer case. So what we'll do next time is we'll raise some funds, and your time is valuable, your information is valuable. It doesn't make you their attorney, so I got to make that clear. It's not advice. It's not any of that stuff until you actually hire Brian. It's not advice, and I think that's true, correct?
Yep, that's a standard, advisement I give during the classes, and obviously during a podcast, I can't give anyone specific advice about, particular questions they have, other than sort of this general advice that we've given tonight.
Absolutely. So, but it kind of helps them bring him back on. Isaac and I do this because we love it. Brian loves doing this as well, but obviously this is he can't be on here every single Monday, and it helps him continue his advocacy on that front. But filing for claims and shit like that, just the shit that he helps us with, just filing a paperwork costs a lot of money and stuff like that. So
why attorneys are so expensive?
Because freedom is
because they're worth it.
Because they're worth it.
Yeah.
I'll say the freedom is worth it.
Yeah.
Well,
that's a play on the joke. Why divorce is so expensive.
Yeah, because it's worth it. Yeah. It's worth it. So maybe next time we'll have a link, and hopefully you guys can help us out, help Brian out a little bit, fight for your Second Amendment privileges at this point. It is what it is. But I appreciate you coming on. I appreciate your knowledge. DenverLawShark.com is your website.
Mm-hmm.
If you want to have a personal conversation with Brian, hit him up that way. And are you on social medias?
Yeah, I actually got a Facebook account, and I think that's the only thing I really maintain is there's a Facebook account with the business name on it.
Okay. So, and that would be what's the business?
So, law firm of Brian DeBush LLC.
Plain and simple, yeah. Pretty easy. Law firm of Brian DeBush. So, Isaac, anything from? Just
a big thank you. A personal thank you for everything you've done for Guns for Everyone, but also a thank you for showing up tonight and the care and the interest you take in getting these things right. It's really important, and it's very useful information for people.
No, I'm glad. I'm glad you guys had me on. It's been a while since we all saw each other, and I appreciate you having me on like this.
Yeah, absolutely. I appreciate everyone that commented, that asked questions, that participated. Like I said, go over to denverlawshark.com, say thanks to Brian, throw him $100 bills or whatever, just so he can continue helping us with this 2A advocacy stuff. I appreciate you guys, and we will see you next week.